ಇದೆ. ಕೋರ್ಟ್ ಆಫೀಸು ಕೋರ್ಟ್ ಆಫೀಸು ಕೋರ್ಟ್ ಆಫೀಸು ಹಲೋ ಮೇಡಮ್, ಲಿಸ್ಟ್ 4 ಈಗ್ಲೇ ಕರೀತಾರ ಹಂಗೆ? ಅಡ್ಜಾರ್ನ್ಮೆಂಟ್ಸ್
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಯಾವ್ದು ಕಾಲ್ ಔಟ್ ಆಗಲ್ಲ. ಕ್ರೋನಾಲಾಜಿಕಲ್ ಆಗಿ ಲಿಸ್ಟ್ ಕರಿತೀವಿ ನಾವು.
ಓಕೆ, ಅಲ್ಲ ಐ ಮೀನ್ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಕರೀತೀರಾ? ಸೀರಿಯಲ್ ನಂಬರ್ಸ್ ಹಲೋ, ಲಿಸ್ಟ್ 4 ಮೇಡಮ್, ಲಿಸ್ಟ್ 4.
ಎಲ್ಲ ಲಿಸ್ಟ್ ಕರಿತೀವಿ.
ಓಕೆ ಓಕೆ ಓಕೆ, ಫಸ್ಟ್ ಕೇಳ್ಬೋದಲ್ಲ? ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಏನ್ ಮೆಮೊ ಸರ್? ಫ್ರೆಶಾ? ಇಡಿ. ಯಾರನ್ನೋ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ ನೋಡಿ, ಅದು ಅಂತ ಅದಕ್ಕೆ ಯಾರೋ ಇನ್ನೊಬ್ರು ಬಂದಿದ್ದಾರೆ, ಅವ್ರ ಹೆಸರೇನು, ಅವ್ರನ್ನೇ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಕೊಂಡು ಪಾಪ ಅವರೇ ಬಂದು ಮಾಡ್ತಿದ್ರು. ಬೆಳಗ್ಗೆ ಸದಾನಂದಲ್ಲಿ ಬಂದ್ಮೇಲೆ ಕೇಳ್ಬಿಟ್ಟು ಹೌದು ಸರ್ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು, ಯಾಕಂದ್ರೆ ಇದು ಅದಾಲತ್ ಸಿಟ್ಟಿಂಗ್ ಇದೆ ನಾಳೆ, ಮತ್ತೆ ನಮ್ಗೆ 1 ವಾರ ಟೈಮ್. ಮೇಡಮ್ ಕೇಳ್ಬಿಟ್ಟು ಕೊಡಿ. ಫೈಲ್ ತಂದ್ಯಾ? ಅದು ಅಪೀಲ್ ಮೆಮೊ ಕೆಳಗಡೆ ಇದೆ ಅನ್ಸುತ್ತೆ, ನೋಡು ಕೆಳಗೆ. ನೀನು ಉಲ್ಟಾ ಆಗ್ಬಿಟ್ಟಿದೆ ಅನ್ಸುತ್ತೆ. 6 ಜನ ಹುಡುಕಿದೀವಿ ಮೇಡಮ್. ತೆಗಿ, ಇದೇನಿದು? ಅದೇ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಇದು ತೆಗಿ. ಇದೇನಿದು? ಅದು ಮೆಮೊ, ಇದು ರಿವ್ಯೂ ಎಲ್ಲ ರಿಸೈಟೇಷನ್ಸ್ ಇದೆ. ಒಂದು ನಿಮಿಷ ಇದು. ಇಲ್ಲ ಇದೇನಿದು? ಒಂದು ನಿಮಿಷ. ಅದು WP ಎಲ್ಲ ತುಂಬಾ ಸಣ್ಣಗಿರುತ್ತಪ್ಪ. WP ಬ್ರಾಂಚ್ ಇದೇನಿದು ಮೆಮೊನಾ? ಇದು ಅದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಇದ್ರ ಜೊತೆ ಏನಾದ್ರು ಹೊಲ್ದವ್ರ ನೋಡ್ಬೇಕಾಯ್ತು.
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಮೇಡಮ್?
ಕೇಳಿಸ್ತಿದೆ.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಕೇಳಿಸ್ತಿದೆ. ಇದೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಿಮಿಷ ಇಟ್ಕೊ. ಇದೇನಾದ್ರು ಬೇರೆ ಇದಿಷ್ಟು ಸಪ್ರೇಟ್ ಇದೆಯಾ? ಕೇಳೋಣ, ಇದು ಅವ್ರನ್ನೇ ಕರಿತೀನಿ. ಇದು ಬ್ರಾಂಚ್ GMFC ಅಲ್ಲ ಅದು? ಅಪೀಲ್ ಮೆಮೊ ಇದೆ. ಇಷ್ಟೆಲ್ಲ ಪೇಪರ್ಸ್ ಇಟ್ಟಿದ್ದು ಇಷ್ಟೇ. ಇದು ಅವ್ರು ಯಾರು ಈಗ ಬಂದಿರೋರು ಯಾರೋ ಮಧು ಸದಾ ವೇಣುಗೋಪಾಲ್, ಅವ್ರನ್ನೇ ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ.
ಇಷ್ಟೇ ತಪ್ಪಾಗಿ ಮಾಡ್ಬಿಟ್ಟು
ಹೌದಾ?
ಮಾಡಿದ್ದೆ ಮಾಡಿ ತಲೆಲ್ಲ ಕನ್ಫ್ಯೂಸ್
ಮಾಡ್ಬಿಟ್ಟವನೇ ಬಂಗಾರೆ.
ತಪ್ಪಾಗಿರುತ್ತೆ ಎಲ್ಲ ಮಾಡೋದು. ಗೊತ್ತಾ
ನನಗೆ ಒಂದ್ ಸಿಕ್ಕಿಲ್ಲ, ಒಂದೇ ಸಿಕ್ಕಿಲ್ಲ.
ಮೇಡಮ್ ಅಲ್ಲಲ್ಲ ಅವರು ಬಂದಿದ್ದಾರೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅವ್ರನ್ನೇ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಕೊಂಡ್ಬರ್ತಾ ಅವ್ರ ನೋಡಿ ಮಧುಸೂದನ್ ಅವ್ರಿಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಡಿ ಅಷ್ಟುವರೆ ಕರೆಕ್ಟಾಗಿ ನಮ್ಮ ಪೋರ್ಟಲ್ ಅಲ್ಲಿ ಏಕೆಂದ್ರೆ ನನಗೆ ರಿಪೋರ್ಟ್ ಮಾಡಿ ಹೇಳಿದ್ದಾರೆ ವೆಬ್ಸೈಟ್ ರಿಪೋರ್ಟ್ ಮಾಡಿ ಹೇಳಿದ್ದಾರೆ ಆನ್ಲೈನ್ ಹೇಳಿದ್ದಾರೆ ಅದಕ್ಕೆ ಬಂದು ನಾನು ನಮ್ಮ ಪಕ್ಕ ಇದೆ ಕೈಯಲ್ಲಿ 4 ಬಂದು ಬಂದಿದ್ದಾರೆ ಬೋರ್ಡಿಂದ ಅವ್ರು ಹೇಳಿ ಇವಾಗ ಬರಕ್ಕೆ ಬೇಗ ಏನು ಗೊತ್ತಾ ಫಸ್ಟ್ ಅವರಲ್ಲಿ ನಾನು ಏನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಏನಂದ್ರೆ ಅಲ್ಲಿ ಡಿಸ್ಕಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ ಅಲ್ಲ ಬಾತ್ ಸಬ್ಮಿಟ್ ಅಂತ ಏನೋ ಒಂದು ಇವಾಗ ನೀವು ಅದು ಆಡಿಯೋ ವೇಣುಗೋಪಾಲ್ ಅನ್ನೋದು ಮಧುಸೂದನ್ ಅಂತ ವೇಣುಗೋಪಾಲ್ ಸೊ ಸೆಪರೇಟ್ ಏನಾದ್ರು ಬಂದಿದೆಯಾ ಅದ್ರ ಜೊತೆದು
ಮೇಡಮ್ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಿಗೂ ಮೂವ್ ಮಾಡ್ಬೇಕು ತಗೊಳ್ತೀರಾ?
ಯಾವುದು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್? ಏನದು ಮೇಡಮ್? DOFC ರಿಟ್ ಪಿಟಿಷನ್ ಯಾವ ಇಯರ್? 2025. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರೆಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಫ್ರೆಶ್ ಬ್ಯಾಟರಿ ಸಿಪಿ
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರೆಸ್ ಕೊಡ್ತೀರಿ ಇವಾಗ 2022.
ಏನಾಯ್ತದ ಇವಾಗ ಅಪ್ರೀ ಮೆಮೊ ಇಲ್ಲ
ಮೇಡಮ್ 24.
ತಗೊಳ್ಳಿ
ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ
ಇಷ್ಟ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಅದಕ್ಕೆ ರೀಸನ್ ಹೇಳಿ ನೀವು. 24 ಈಗ ಕರೆಕ್ಟ್ 24 ಅಂತ ಇದೆಯಲ್ಲ ಸಿಪಿ ನಂಬರ್ ಮೇಡಮ್ ಕೇಳ್ತಾರೆ ಮೇಡಮ್ ನೀವು ಹೇಳಿ 24 ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾ? ಇದೆಲ್ಲ ಫ್ರೆಶ್ ಮಾಡ್ಕೊಂಡು
ಅಲ್ಲೇ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್ಗೆ.
ಅದು ಡೇಟ್ ಇರೋ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಮೇಲೆ ಅದು ಅದೇ ನಮಗೆ ರಿಪೋರ್ಟ್ ಆಯ್ತಾ ಪ್ರಿನ್ಸಿಪಲ್ ನಾವು ಇಲ್ಲಿ ಕಟ್ ನೋಡಿ ಇಲ್ಲಿ ಹೇಳಿದ ಬೋರ್ಡ್ ಇಂದ ಕಳಿಸಿರಲ್ಲ
ಸರ್ ಇಲ್ಲ
ನಾವು ಈ ಚೇಂಜ್
ಮೇಡಮ್ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ MBM ಅದು ಇವರೇ ಇನ್ಚಾರ್ಜ್. ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್
ಕಾಂಪಿಟಿಷನ್ ಅಂದ್ರೆ ಮೋಸ್ಟ್ಲಿ ಎಲ್ಲ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು ಸರ್ ಇದಾರೆ.
24 ಎಕ್ಸೆಪ್ಟ್ 25 ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರೆಸ್ ಬಿಟ್ಟು ಬೇರೆದೆಲ್ಲ ಸಬ್ಮಿಟ್ ಮಾಡಬೇಕು.
ಮೇಡಮ್ಗೆ ಹೇಳಿ ನೀವು ಹಿಂದಿನ ಫೈಲ್ ಇಲ್ಲ ಹಾಕಿದ್ದೀರಲ್ಲ
ಅದರಲ್ಲಿ ಅಪೀಲ್ ಮೆಮೊ ಕಾಪಿ ಇಲ್ವಂತರಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆಯಂತೆ ಅಪೀಲ್ ಮೆಮೊ ಕಾಪಿ ಅಲ್ಲಿ ಇಸ್ಕೊಳ್ಳೋದಾ ಮೇಡಮ್? ಫ್ರೆಶ್ ಅಂತ 25 ಏನ್ ಮಾಡೋದು? ಇದೇ ಏನಾದ್ರು ಆರ್ಡರ್ ಸಬ್ಮಿಟ್ ಮಾಡಿ
ಅವ್ರಿಗೆ ಇಲ್ಲದಿದ್ದ ಜೊತೆಗೆ
ಏನ್ ಮಾಡ್ತಾರೆ ಗೊತ್ತಾ? ಕನ್ಸಿಲೇಷನ್ ತರ ಕ್ಯಾಲ್ಕುಲೇಷನ್
ನೀವು ಅಲ್ಲಿ ಹೇಳಿ ಮೇಡಮ್ ಯಾವ ಮ್ಯಾಟರ್ ಎಷ್ಟು ಅರ್ಥ ಆಗಿದೆ ಹೇಳಿ ಕರಿತೀನಿ ನಾನು ಮಾಡಿ ಬಟ್ ಯು ಹ್ಯಾವ್ ಅಪಿಯರ್ಡ್ ಇನ್
ನಾಗೇಶ್ವರಿ ಮೇಡಮ್ ಅವರು ಕಳಿಸಿದ್ದಾರೆ. ಅವ್ರ
ಏನು ಬೆಳಗ್ಗೆ ಆ ಲಿಸ್ಟ್ ನಲ್ಲಿ ನನ್ನ ಕಾಲ್ ಲಿಸ್ಟ್ ಕೊಡ್ತಾರೆ. ನನ್ನ ಕಾಲ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಅರ್ಥ ಆಗುತ್ತೆ? ನನ್ಗೆ ಅರ್ಥ ಆಗಲ್ಲ.
ಹೇಳ್ತಾನೆ ನೋಡಿ, ನಮ್ಗೆ ತಾನೇ ಬಂದಿರೋದು. ಅವ್ರ ಮಧು ಅಂದ್ರೆ ಅವರೇ ತಾನೆ.
ಮಧು ಅದೇ ಹೇಳಿದ್ದೀನಿ
ಅಲ್ಲೇ ಇರತ್ತೆ.
ಮಧ್ಯಾಹ್ನ ತಕ್ಷಣ ಅದು ಯಾವ ಟೆಕ್ಸ್ಟ್ ಇದೆ ಇವ್ಯಾವ್ದು ಯಾವ್ದ್ರಲ್ಲೂ ಇಂಕ್ ಇಲ್ಲ ಎಲ್ಲ ಎಕ್ಸಾಸ್ಟ್ ಅನ್ಬಿಟ್ಟಿದೆ ಅಷ್ಟು ಪೆನ್ ಈಗ ಸದಾನಂದ
ಎಷ್ಟೊಂದು ಇಲ್ಲಿ ಹಾಕಿದ್ದೆ ಅದು ಯಾವ್ದು ಕಾಣ್ತಾನೆ ಇಲ್ಲ ಅಲ್ವಾ ನಾಳೆ ಕೊಡ್ಬೇಡಿ ನಾಳೆ ಲೋಕದಾಗ ನಾಳೆ ನಮ್ಮ ಸಿಪಿನೇ ಕೊಟ್ಟಿಲ್ಲ ನಾಳೆ ಮೇಡಮ್ ಸದ್ಯಕ್ಕೆ ಮ್ಯಾನೇಜ್ ಮಾಡ್ತಾರೆ ಸದಾನಂದ
ಕೊಡಿ
ಇದೆ ಓಡುತ್ತೆ ಮಧ್ಯಾಹ್ನದವರೆಗೂ ಓಡುತ್ತೆ
ಆಯ್ತು ಮೆಮೋ ಬುಕ್ಕು ಅಲ್ಲೇ ಕೊಟ್ಟಿದ್ದೀನಿ
ಇದೆ ಕೊಡ್ಬೇಕು ಮೇಡಮ್ ಅದೆಲ್ಲ 3 ದಿನದಲ್ಲಿ ಯಾವ್ದೋ ಒಂದು ದಿನ ಕೊಡಿ ಇಲ್ಲಿವರೆಗೂ ಏನು
ಫೈನಲ್ ಇಯರಿಂಗ್ ಎಲ್ಲ ಇಲ್ಲ ಯಾವ ಇಯರ್ ನೋಡಪ್ಪ ಅಪೀಲ್ ಮೆಮೊ ಕಾಪಿ
ಮೇಡಮ್ ಅವಾಗ ಅವ್ರು ಯಾರೋ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರು ಅಂತ ಕೊಟ್ರಲ್ಲ ಆ ಡೇಟ್ ಅದು ಬೇಡ ಬಿಡಿ ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಂತ ಬರ್ಬಿಡಿ ಮೇಲೆ ಫೈನಲ್ ಇಯರಿಂಗ್ ಹೆಂಗ್ ರಿಜೆಕ್ಟ್ ಆಮೇಲೆ ಅವ್ರು ಬಂದು ಕೇಳ್ತಾರೆ ಯಾಕೆ ರಿಜೆಕ್ಟ್ ಮಾಡೋದು ಅವ್ರು ಯಾರೋ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರು ಅಂತ ಕೊಟ್ರಲ್ಲ ಮೇಡಮ್ ಅವಾಗ ಯಾರೋ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿಲ್ವಾ ಅದನ್ನ ಹಾಕೊಳ್ಳಿ ಅವ್ರು ಹೇಳಲ್ಲ
ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಂತ ಅವರು ಕ್ಯಾಪ್ಷನ್ ಹಾಕಿದ್ದಾರೆ ನೋಡೋಣ
ಆಮೇಲೆ ಮೇಡಮ್ ಆದರ್ಶ ನೋಡ್ಕೊಂಡು ಆದರ್ಶ ನಾನು ಇಲ್ಲಿ 6 ಜನ
ಆಯ್ತು ಇಟ್ಕೊಂಡಿರು ನೋಡೋಣ ಇದ್ರೆ ತಂದು ಕೊಡ್ತಾರೆ ಇಲ್ಲ ಅಂತ
What up, sir? What up, sir?
ಹೇಳಿ ಸರ್
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇಲ್ಲ ಮಧ್ಯ ಆರ್ಡರ್ಸ್ ಆದ್ಮೇಲೆ ಅದ ರೀತಿ ಹೋಗ್ತಾನೆ
ಸರ್ ಇಷ್ಟು ದಿನ ನೋಡಿದ್ದೀರಲ್ವಾ ಕ್ರೋನಾಲಜಿಕಲ್ ಆಗಿ ಹೋಗುತ್ತೆ ಲಿಸ್ಟು
ಅಂದ್ರೆ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಫೋರ್ತ್ ಲಿಸ್ಟ್
ನೀವು 10:30ಗೆ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಇರಿ ಸರ್
ಇದ್ದೀನಿ ಈಗಾಗಲೇ
ಮೇಡಮ್ ಬಂದಾಗ ನೀವು ಇರಿ ಮೇಡಮ್ ಏನ್ ಹೇಳ್ತಾರೆ
ಅಲ್ಲ ಇದು ಬೇರೆ ಬೇರೆ ಲಿಸ್ಟ್ ರಿಜಿಸ್ಟರ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ
ಇದುವರೆಗೂ ಲಿಸ್ಟ್ 1 ಲಿಸ್ಟ್ 2 ಲಿಸ್ಟ್ 3 ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಬೈ ಕ್ರೋನಾಲಜಿಕಲ್ ಆರ್ಡರ್ ಏನಾದ್ರು ಆಲ್ಟರೇಷನ್ ಆಯ್ತು ಅಂದ್ರೆ ಗೊತ್ತಿಲ್ಲ 10:30ಗೆ ನೀವು ಆನ್ಲೈನ್ ಇರಿ ಮೇಡಮ್ ಬಂದಾಗ ಏನ್ ಹೇಳ್ತಾರೆ ಅದು
ಓಕೆ ಮೇಡಮ್ ಥ್ಯಾಂಕ್ ಯು
My lord.
The receipt filed by the KSRTC Enhancement, 50% of the amount has been ordered to be deposited. The amount has been kept in FD that has been matured. Now I am filing application seeking for the withdrawal of the amount.
That's
Mala.
total 20 matter minutes. Writ petition GM FCP minutes. Let the executing court declined to execute the order, compromise order passed by the honorable court minutes. On 21st, the matter was listed minutes. The Lordship was pleased to pass an order reserving liberty for me to approach the executing court. Yesterday it was listed. Just the executing court quoted the matter after vacation without without directing the JDR to hand over the child prisoners. I am entitled for 75% of
Okay, sir. Court visible illa. Will not entertain that now.
Millet, I have filed an application,
No.
please, Millet.
Yes.
During pendency of
We'll
this.
see after vacation, no? Yes.
Millet, I am entitled for.
Yes, yes.
Despite your lordship orders, it was not listed. Yesterday I moved this memo, my lord. Papa, release of cash security amount, my lord. He is a senior citizen.
Yes.
230, maybe take up for 230.
No, when the matters are listed after vacation, how you are making a mention again?
Yesterday-
For listing it?
Lordship, the matter was listed on that strike was going on.
Hmm.
We could not attend the proceedings, my lord.
That day it was.
Yes, my lord. 23rd.
Yes.
Make it to 230, lordship.
Some no 2:30. We'll
Please.
see tomorrow.
Please.
Yes.
This is fresh company application about.
Company, this court is not having the company application.
No, what has happened, this company application 234/2020 was disposed. My lord, on that day I could not, due to my ill health, I could not able to present. Then I could not able to file a memo for that way of that amount. My lord. Now I have filed a recall application, my lord. I have it on tomorrow or Monday, my lord. I have filed fresh application.
When was the order passed?
Order passed in just 1.5 months back. My lord.
Just 1.5 months back. We'll hear it after vacation.
There is some
After
urgent-
4 months, no.
there is
What
some-
urgency was not there from the
I was
1.5
not-
year?
no, I
No,
was
will
not-
not hear, will not hear.
I have it on
Yes.
Monday.
No, I have, the court has lot of matters. When you are not, when there was no urgency from the last 1.5 month,
No,
not before
in fact, I was
not before the packet of the
keeping
vacation.
well, my lord.
I'm sorry. Yes.
Tuesday.
No.
Yes.
Yes, tomorrow.
Let's two matters. One is pertaining to your lordship's bench, wherein in chambers, wherein the settlement was agreed for $1,000. That matter was to be listed. The date given matter is not being listed. I request because ensuing vacations for the father would want the date given matter.
I think all these matters, some of the clients are feeling that the court has no other work but to only deal with them. Then I think for every listing, court should ask them to pay at least 50,000, which shall be paid to the Legal Services Authority.
But the date was given in this matter, it did not come up.
When the date was given,
Matter was in fact to be listed on 10th of April as per my knowledge, and it's not come up. Then we thought it would come up the next day. It didn't. So now I've been.
but from 10th of April till now, you didn't ask for it. Why it is not listed when a direction is there? Find out. And on that day, I am not going to entertain all these applications, and I'll delete it from Packard also on that day. Tell your clients, because they are thinking that they are doing some favor by compromising the matters, and court's time is very valuable, and that they ought to realize that for them the court is working, and they just like that, as if court is a third party and they will be.
I in fact informed my learned friend also that all seems to be well between the parties because of I think this could.
That's what. If any of them are not realizing that they don't want to compromise, let it go. Let it go. Court is least bothered, and people who are interested to settle their disputes, that the court will hear. Yes, let it come on Saturday or Monday, basing on the list. Yes.
Minutes quote on 20 matter my lords. The father has taken the custody of the children and I've been given only visitation rights, my lords. But problem now arises when children have their school vacations. At least if I could be at least given 2 weeks of their custody, my lords.
Why you are moving it today? Why not before?
No, my lords, what has happened is there was an order by this honorable court that you continue to exercise, let the bonding develop. After that, let the mother start taking the children to her custody, and moreover, they live in the same vicinity, my lords. An order was already passed by the regular roster, my lords, wherein I have given only weekend visitation rights. And also, my lords, I have in fact come.
No, that will not be keep on changing for every 10 days, 15 days.
No, madam. She's getting
When was that order passed?
And the order was passed on the, madam, I don't remember the date, if I'm not wrong, it was passed on 11th of March, my lords. So what happened? She's continued to exercise the visitation rights and she gets only four hours every week, my lords. Now, my lords, since we've been informed that there are school vacations, that being the reason, my lords, I'm not even asking for 50%, my lords, at least 2 weeks with the mother, my
No,
lords.
if I feel that there are no grounds, I'll dismiss the petition itself.
Please. Monday.
Transfer petition for withdrawal of the petition.
My lord, MFA 2017 matter, my lord. It has been dismissed in trial court, my lord. 2 minor children are there, my lord. For June school, the party called for amount, my lord. So kindly, my lord.
2017.
Yes, my lord.
2025, there is urgency before vacation.
She called up yesterday and told the husband death, my lord.
No, will not take up this. No.
Number 1.
Pursuant to the order possibly, they are filing contempt petition. They are in their.
Let them file. They will file.
That notice was issued. I'm sorry,
No.
my lord. I'm not able to.
Serial
I will on
number,
Monday. I'll Tuesday, my lord. Now they are filing contempt petitions.
Let them file. Let them file. Why you have not? They give one reason.
I'm apologizing.
First of all, why you have not appeared? Why you have not chosen to file any application from the last 1.5 months? And whenever a contempt is moved, you will not move the application, and court should also have time to entertain all that. No,
I'm apologizing. I'm sorry. I
will not entertain, Mr. Counsel. Please understand.
Monday, I'll Tuesday, my lord.
No, there are so many matters on Monday and Tuesday.
Tomorrow.
Tomorrow also there are so many matters. Yes, call the list.
number 1.
Wednesday.
My lords, may I make a motion, my lords?
Yes.
My lords, I'm appearing for the petitioner in list number 2, serial number 2, my lords. My lords, this is a matter pertaining to where the child was to be sent to Enhancement for counseling, my lords, in accordance with which orders for visitation would also be provided to the petitioner regarding whether the petitioner is able to bond with the child. Your lordships had passed the order on 21st of this month, seeking report from NIMHANS whether such interactions are, whether the petitioner is able to interact and form a bond with the child. My lords, a report is still awaited. The matter may be taken up next week, my lord, Monday or Tuesday, my lord. The child has ensuing summer vacations, my lords.
We will see when the matter reaches. Yes.
My lord,
Please, my lord.
Yes.
serial number 5 served on me. I am not an advocate for the respondent. So I would
Please wait till your matter reaches. No, please call the list. Yes, first matter.
Serial number 1, R. Shashidhara for appellant.
For the second
B.
respondent.
Pradeep.
Where is Mr. Shashidhara?
I think the company appeal, I have noticed that, my lord, the company appeal has been filed before this honorable court. After disposal of this company appeal,
Yesterday, you were
Yesterday,
saying. Pass over.
please.
Inform him or else I'll dismiss it.
Serial number 2,
In this case, appellant.
R. Shankar.
In this case, petition was one is the father of the deceased one. He is no more. He is died after pronouncement of judgment. So petition number 2 is the LR of petition number 1.
In the cause list, his name can be shown, died for LRs. Why not?
I already mentioned.
Not note. Cause title itself it should show. Do it. Office objections to be complied with within a week. Yes, next.
Serial number 3. Serial number 3.
Finally, a week's time is
Yes,
granted.
I appear for the appellant.
Why you are not complied with the office objections?
No, the office objection is with regard to non-filing of the IA for condemnation delay. But the judgment is passed on 18th March 2025. There will
That
be
you can tell the registry also.
filing a memo with regard to that.
What memo? Why should you file a memo before this court? When objection is raised by the registry, you should tell the registry.
But yesterday I could not do that, nurse. Therefore, nurse, I am
Today
requesting.
also, the court also can't do anything
But, sir,
to comply with the office objections.
Mr. Lordship may kindly post it on Tuesday, nurse. Actually,
Yes, this is matter on Tuesday if office objections are complied with.
great.
Yes, 4.
Serial number 4. Serial number 4, Rupesh Kumar for maintenance.
No representation for dismissal. Yes, next.
28 for appellant. Serial number 5. A. John
For
Bosco.
complying with the office objections, a week's time is granted.
Till number 6.
My lord, matter is settled between the parties, my lord. I'm filing a memo for bidder.
Take that.
An amount of rupees 18,000 has been deposited in this one, my lord. It may be released in favor of the petitioner, my lord. I'll may be permitted to produce the copy of the mediation agreement which says that the petitioner is entitled to be. It may be released in.
No, you must have filed a agreement and all before
Yes.
the court below.
I have filed, my lord.
Then why all this to be recorded? No, as far as this petition is concerned, in view of the settlement.
Yes,
this
as per the settlement, I am entitled, as per the settlement clause, it is in my favor, my lord. I may be permitted to produce the copy, ma'am.
No, this, you must have compromised the matter before the
Yes,
trial.
we have compromised, everything is settled, the case is disposed there, my lord. But 80,000 has been deposited pursuant to the order of this honorable court, my lord.
Here it is.
Yes, my lord. It is deposited here, my
Where
lord.
is the other side?
But I requested him to be present, but
Also, let him come.
my lord, may I submit the copy of the mediation?
See, ask him to come. If he doesn't turn up in the afternoon, then we will see.
Please,
Pass
ma'am.
over. 7.
Till number 7.
Your ladyship, the office objection is redundant. I may persuade your ladyships. In the cause title, we have mentioned the initials. They want the full form. I can do it. And the second part is the jurisdiction is rightly stated. This is the same case arising out of your impugned order. A short question of law on order.
Jurisdiction to be stated correctly at cause title.
We have stated.
Party's name to be stated.
Yeah.
Red petition
Juliet
cause title.
Fuckreja.
For exigency.
Yes.
Copy to be served on the caveator
It
and
is served.
acknowledgement to be filed.
We have already
Served?
filed. Yes. They
Before
can be
for all.
overruled.
Hmm.
May I submit, your ladyship? Short question on order 21, rule 6. The rule has been made absolute by this honorable court itself via a judgment, but
Judgments are required. First tell
fine,
the facts.
fine. Your ladyship, the impugned order was released on 29 March. It was uploaded and we got the certified copies on 29th March. And we had to apply to the Honorable Supreme Court. In the
When did you
meantime,
file the appeal?
yeah, in the meantime, your ladyship, the respondent has filed.
When did you file the appeal before the?
It's filed on 17th.
17?
17/4.
When is it coming up?
Your ladyship, next week. Probable date is 30th.
Hmm.
That is all we were asking, but the respondent herein had moved execution on first itself without putting the certified copy of your impugned order. He put an internet copy. That's where the confusion started. So under order 21 rule 6, we filed on 11th itself.
The order?
Yes, your ladyship. The impugned order is at page number 19. The only reason given is at page number 8 that the execution hasn't been sent to the honorable trial court. Hence, our application is not maintainable in page number 8. Internal page number 8, running page number 26, your ladyship. The honorable trial court says a cursory reading. I am not able to file this application itself, though it is a statutory proviso.
What do you say?
So, Your Honor, first of all, they have approached this court with unclean hands. They have not.
They're not on that point.
Right.
Order is released on 29/3/2024.
It's admitted
Appeal
in
is
host.
filed on 17/4/2024. We'll give them a time till 1/5/2024.
Highly obliged.
So by the time if they get the order, any order from that, or else the trial court will proceed with the matter.
Allow me to demonstrate this writ is not maintained. So if you see, Your Honor, first of all, the reason too that has been given in the order, right? It says no sufficient cause has been demonstrated. Now there is a typographical error in the family court order that they are trying to leverage here to say that the family court has misunderstood the statute. It is very clear, it is the welfare of the child that is the paramount. And if you look at the statute, it is meant for a money decree or a property decree, right? And if you look at the sufficient cause clause, I would request the court to look at their application that they have filed at page 47 of the writ petition, para 7, right? If I may read it for the court. At para 7, they read that the summer vacation of the minor ward, Ms. Pahul, starts from 10/4
2025 to 26/5/2025. Therefore, the rights of DHR to the interim custody commences from 3rd May 2025, and the cause of action starts from 26/5/2025. What they are really saying is the cause of action for me to file execution starts after the summer vacation is over. That itself shows there is a malified intent behind filing this application, because on one side of the mouth they say my rights commence from 3rd May. However, the cause of action arises after the summer vacation is over. So we had highlighted it to the trial court that there's a malified intent. You look at the points they are raising here. Not just that, the execution court ordered on 13th April 2025 access as per this honorable court's order on a Sunday, and they did not honor that. I went ahead and on 16th April filed an affidavit before the family court, which they have concealed before this court, and they did not appear on that day, although the notice was served on them. We argued that if they are not following executing court's order, how can they get any relief from the executing court? So the stay provision, what they have raised, is with a malified intent. The intent is to cause delay, let the summer vacation pass away, and the child does not get time to spend with the father. Now, I would also propose that writ petition at the onset is infructus. If I draw the court's attention to the judgment they are relying on.
I have not even heard what is the judgment they are relying on, because I am not going into the judgment at all.
Your Honor, the judgment clearly says.
I am not looking at their judgment.
Okay, so the principle that the judgment enunciates is.
Will not. You don't have to submit when I am not considering.
Okay.
Don't submit on the judgment. Yes.
I refrain from rebutting all the false submissions.
Let him say. Let him come.
So, Your Honor, I'd like to place these additional documents that have been suppressed before the court. This actually contains the affidavits that are filed in executing court and shows that they were violating the executing court's orders. Hence, they were not entitled to any kind of refund. Forgetting if it was filed with a malified intent. In this writ petition itself, they have, besides having come with unclean hands, they have again used defamatory language. This court itself had issued a direction to them to not use any defamatory language. If you look at the para 16.
No, we will not go into all
not
that.
Defamatory, inappropriate.
Limited issues with regard to
we have not
their appeal filed before the Honorable Apex Court.
Yes.
Will grant them time till 1st of May. By 1st of May, if there is no order passed by the Apex Court, interfering with the order passed by this court, the executing court is at liberty to execute the decree.
So, Your Honor, that's where I'm trying to say the Karnataka High Court judgment clearly says that if an appeal has been filed.
That we know the legal position. Here we are talking, we are on an issue
the IA was filed before the
with regard to the child and their rights. Let that be. That is the general law.
I seek kind intelligence. Just one para, Your Honor, if you may read, please.
It is settled law. When again it's an order, when an appeal is preferred, that is for that court to grant an interim order. Till such order is not granted, executing court will execute the decree. That is a settled law. For that, no judgment is required.
Your Honor, the judgment here clearly says if the appeal has been moved, they no longer have they cannot come to the lower courts and seek stay because the appeal has already been filed. They have to go before the Supreme Court and get a stay from the Supreme Court. The correct procedure for them was to go in the original WP 10091 and file an application seeking a stay.
Now you go to the Supreme Court against this order. Please come. The present petition is filed.
First is a holiday, your ladyship. Second.
Yes, so this petition is filed. Agreed with the orders passed in executing EX number 81 of 2025 dated 17th April 2025, wherein an application is moved for staying all further proceedings in the execution case to enable them to file the special leave petition for the Honorable Apex Court to challenge the order dated 29/11/2024, released on 27/3/2025. It is submitted that an order was passed on 29/11/2024 and the same was released on 27/3/2025, and they were approached the Honorable Apex Court
on 17/4.
on 17/4/2024, and
With
the
diary
matter is to come up before it's likely to come up on 30/4/2024. When they sought for the stay of all further proceedings by way of the impugned order, the trial court has dismissed the same, and the court has also observed there is nothing on record to believe the contention of the judgment that the order dated 29/11/2024 in WP number 10091 and 19407 of 2024 was released on 27/3/2025, and as the executing court cannot interfere with the order passed by an appellate, cannot stay the order passed by the appellate court, then counsel appearing for the judgment that the oblique petitioner submits that the executing court has such a power to stay the proceedings pending further orders from the Honorable Apex Court. Then the respondent further appeared as party in person submits that when an appeal is filed, in the light of the settled law, they have to seek directions from the appellate court, and the executing court cannot interfere with the same, and is ought to rely on the judgment passed by a coordinate bench of this court. It is submitted that they have not come before the court with unclean hands, and certain statements are made before the court which are derogatory or defamatory in nature in spite of an order passed by this court. It is submitted that the mother was never obliging the orders of the court, and she cannot seek any interference from the court, and the court had rightly dismissed the application. Next paragraph.
I controvert all these allegations.
Having heard the counsels on either side, produce a material on record. This is a matter pertaining to the custody of the child. An order was passed by the court, and the order was released on 27/3/2025, and admittedly an appeal is preferred before the Honorable Apex Court, and it is likely to come up on 30/4/2024. Without going into the legality or otherwise of the matter, this court is of the view that an opportunity needs to be, as already an appeal is, the order is assailed before the Apex Court, a reasonable opportunity has to be given to the party. In that view of the matter, this petition is disposed of, directing the trial court, not executing court, not to take further steps till 2nd of May, and by 2nd of May, if the petitioner fails to get any order from the Apex Court, the executing court is at liberty to execute the order.
So, Your Honor, the impugned order has some corrections. So they may be directed to place the corrected record before the Supreme Court and not mislead the Supreme Court that the merits of the case are loose.
That I have seen. That is not going to have any great impact on the order.
The SLP was already filed.
They have been arguing.
The SLP was
Then
already
how can
filed.
this court direct them to say that you filed this document? Be reasonable.
Highly
Yes,
obliged.
next.
Cell number 8, Gauda Enna.
Yes. I number notice. Next.
Cell number 9.
This
Cell
also
number 9.
notice. 10.
Cell number 10.
My lord, I am for the appellant, my lord. The
Number-
original certificate copy is produced in the connected MFA, my lord, 2638/25, that matter is already stayed by the division bench.
Certified copies of the judgment. But the IA is ordered for the present. The IA is ordered dispensing the protection of the same for the present.
I have sought for the, I have sought for the same, my lord. My lord, vehicle is not involved and there is no DL. False implication, it is a case of self-fault. The division bench already stayed the connected matter.
The land counsel for the appellant submits that the vehicle involvement of the vehicle is in question, and further there is no driving license. On that ground, they are before this court. Considering the submission, they shall be stay of all further proceedings. On the condition that the appellant shall deposit 50% of the amount within 4 weeks.
6 weeks, my lord, vacation.
For the MACT.
My lord, before High Court, my lord, in the connected matter.
No, let it be. Why all this exercise we are doing
Please,
in every case before the MACT, and on such deposit, the claimants are at liberty to withdraw half of the deposited amount.
My lord, the involvement itself is delayed.
Which is subject to further orders passed by this court.
Still number 11.
Yes.
My lord, this is an ex parte judgment passed by the tribunal, my lord. Though there is no negligence and involvement, my lord, liability is fixed.
On furnishing the security. Yes.
Please, this matter, my lord. It's an ex parte judgment, my lord, challenged by the insurance company. My lord, all the 3 respondents are replaced ex parte. My lord, though the negligence is on the part of the other vehicle, liability is fixed on our vehicle. But for a police case against the other vehicle, I am ready to deposit 50% before High Court, my lord.
Same order in this also. Same order. They are entitled to withdraw. Yes.
Subject to furnishing security.
Yes.
Much.
Still number 12. Rangaramu V. For petitioner.
This is the husband petition, my lord. The respondent filed the application under section 24 of the.
How much is the amount granted?
25,000 rupees, my lord.
What is your income?
Income is 82,000. Out of 82,000, he has to look after his aged parents and also expenses. He is in a rented house, my lord. I have shown at page number 96, my lord. In income and expenditure.
What is wife's income according to you?
Wife is a graduate. She is residing along with her mother at Mangalore. And they purchased the house and also they kept some fixed amount.
Yes, pay 15,000 and arrears at 15,000.
10,000 rupees I am ready to pay.
It is submitted that the
10,000 rupees may be permitted to pay.
It is submitted that the present writ petition is filed, agreed with the orders passed by the tribunal, orders passed by the family court, whereby the interim maintenance of an amount of rupees 25,000 is granted to the wife. It is submitted that the wife is graduate, and she is staying along with the parents. It is submitted
along with mother.
Along with the mother, it is submitted that the income of the husband has to take care of his aged parents and also living in a rented house, and the amount that is granted by the tribunal is on the higher side. Considering the same, they shall be stay of all further proceedings on the condition that the petitioner shall continue to pay an amount of rupees 15,000 as 15,000 by 5th of every succeeding month, and the arrears from the date of petition till today, the arrears at the same amount within 8 weeks. Same, either this or that, the stay granted by this court stands vacated. The petition is permitted to, the petition shall serve the hand summons on the counsel appearing before the trial court and shall file a memo to that effect. Yes, next.
Still number 13.
13, my lord, I appear for the KSRTC third respondent.
Yes, what is this?
50% negligence against the KSRTC and as well as insurer of the vehicle.
There are involvement of 2 vehicles. The fracture is.
Anyway, your appeal is not there.
No, my lord. We are satisfied. Both we have satisfied.
Right? You are on enhancement.
Please.
Let us see. Come to that.
Fracture of mandible.
Page number. Where is the table?
Para number 17, my lord.
Global compensation of 1,50,000
is awarded.
Like, was there any negotiation on this?
We have negotiated, but my learned friend has not agreed.
That you come out with what?
Only 1,50,000 is
1 lakh.
awarded, madam.
1,50,000.
Doctor assessed for
How are they? How
1,50,000 has been awarded, my lord. We offered 1 lakh additional,
Another 1 lakh addition.
inclusive of interest.
We'll make the calculation.
Please, madam.
If it is below that, then you accept what they are
Doctor
saying.
assessed 20% whole body disability.
Let's see. Where is that? There is no table.
17 minutes.
Para
Table.
17 may kindly be seen.
There is no table, madam.
It's just a global
Global compensation awarded.
Let us just calculate what are the injuries.
Fracture of mandible, that's all, my lord.
One fracture. And then 40,000. Any medical bills?
Medical bills for amount of rupees 6,000 something is
6,786. 768.
768.
He is impatient for period of 6 days. 6 days, madam.
6,000.
And the doctors assessed the whole body disability at
1 minute. Whole body disability?
At 20%, madam.
It is on the higher side.
Like regarding that, my lord, there is no loss of future earnings because my lord, doctor admits in the course of
first of all, what is the evidence to disbelieve the evidence of the doctor?
mandible fracture, how it will affect the occasion.
No. Whether it will affect your this thing or not, whether it constitutes the permanent disability to the body to some extent or not is the question.
10 submission. And also,
for example, no, if it is on 10, 20, if we take it at 10%, now what is which year is the accident?
2019.
18.
2018. What is the income?
12,500.
So 12,500 into 12. What is the multiplier?
17. 18 is multiplied. Age is 17 years.
Not student, my lord.
18 into 10 by 100.
That is a student.
But student, we are considering. In fact, if it is engineering and all, we are considering more. 18 into 10 divided by 100. It comes to 2,70,000 itself. It will come.
And also, doctor assessed future medical expenses for 90 to 95,000, madam.
For what? 95,000. What will do?
To remove metal plates.
Actual medical
In the lower mandible. In the that is stated in para number 18 of
that
the.
is on the higher side. So, then the loss of he is a student. So it will.
They have not at all pleaded the income.
No, it is 1.5 lakh. It is given another 1.5 lakh.
That's what my lord I will suggest.
Okay.
Another 1.5 lakh.
1 lakh. Yeah.
1.5.
Inclusive of interest.
It is submitted by the land council appearing for the. No, the other one. They are also. Both the councils, Mr. Nagaraj.
Yes, madam.
Both the council submits the council appearing for the Sriram General Insurance and the council appearing for the RTC submits that they are ready to pay an amount of rupees.
Malad, my submission is the compensation granted is already on the higher side.
No, it is for the joint memo. We are passing the order.
Malad, I can't without the consent of my party. Therefore,
Your RTC yesterday they were there. What we'll do is that day, like in the meantime, we'll post this matter tomorrow. It is submitted that the over and above the compensation that is granted by tribunal and an amount of rupees 1.5 lakh at 6%.
Not inclusive of interest. 1,50,000 inclusive of interest. Because they have not at all pleaded the income.
They are ready to pay and they'll file a joint memo. Place this matter before the Lok Adalat tomorrow. Yes, next.
14. Of injury, my lordship.
Prakash MH.
Was aged about 33 years. Table in a synopsis.
For the appellant, Your Lordship. Case of injury. This case of injury, Your Lordship. Accident is the year of 21.
Come to the table.
Please,
Table in synopsis. My lordship.
Please, Your Lordship, in synopsis.
There is no table in.
Who is there?
How many are the injuries?
4 fractures. Total.
4 fractures.
2 fractures.
4. Total 4.
4 fractures. 80. Medical expenses as it is 4,27,170. Loss of, how many days you were, it was in hospital?
11 days.
11 days.
How much was granted?
7,000, Your Lordship.
Plus,
No, that is laid up period.
huh?
That is laid up period. Laid up period.
11 days. Court has granted how much?
11,000.
11,000.
11,000. So we'll continue that. Then loss of income during laid up period.
Laid up period. 7,000 has been.
Which year is 7,000 is
21.
income to be taken?
7,000 awarded. Madam.
Awarded.
15 days like.
No, no. For
The court-
15,000.
The court coming to the conclusion that Milord, he has to take rest for 15 days. That's why 7,000 awarded.
With 4 fractures, sir.
Income consider, please. Income consider 12,882 minimum wages.
ECT, the rising, no, then?
MSCT has considered minimum
No,
wages.
we will consider now.
15,000.
15,000.
15,000. So 15 into 4.
Lordship, disability is considered as a law
complete
contract.
the first part.
Please.
60,000. According to the doctor, what is the disability?
45.69% of the whole body.
Not whole
And
body,
requires
madam.
5 more
Not whole body.
surgeries.
MSCT has wrongly
It
stated
is to
that.
the limb.
This is a limb. Para 18.
Let's see.
Fractures are on both the legs, Your Lordship.
Let us see. Read it.
Para 18, Milord. PW3.
Has assessed the permanent residual physical disability of 26.69.
10%
And
contributed
plus
right lower
49.
limb.
It will be 45.69 to
the
the
limb.
limb. So to the whole body it should be
15%.
0.69.
But MSCT has already taken 25%.
25%.
It has to be 15.23.
MSCT has already considered 25%.
25%. They have taken 25%.
So we'll see, because with this increased income, how it will be. So 15 into, what is the?
33 years. Milord,
33 years.
33.
So what is the multiplier?
16.
16 into 15.23. We'll round it off to 16. It comes to 4,60,800. And as per the tribunal?
6,18,336.
So I think it's not a case for enhancement. No, the difference itself is coming to 2.5 lakhs here.
Because
The calculation itself is wrong. We'll discuss your case. Please come. Agreed with the orders passed in MBC number 687 of 2020 date 12 December 2023. The claimant is before this court seeking enhancement of the compensation. This is a case of the claimant that he has sustained injuries in the road accident that had taken place on 1/8/2021, and the tribunal had granted an amount of rupees 11,28,506 for the injuries sustained by the claimant. When counsel appearing for the appellant submits that the court had taken the income at 7,000.
No, my lord. 12,000.
12,882.
882, and the court order have taken 15,000 as the income. It is submitted that under the other conventional heads also the amount that is granted by the tribunal is on the lower side, and the amount needs to be enhanced. Next parallel, and counsel appearing for the respondent insurance company submits that when it is evidence of the doctor that the limb disability is 45.69%, and it comes to 15% to the whole body. Court had taken
25%.
25%, which is on the higher side. It is submitted that if it is calculated at 15%, already the amount that is granted by the tribunal is on the higher side, and the claimant is not entitled for not entitled for enhancement of the compensation. Next paragraph. Having heard the counsels on either side, produce the material on record. As rightly contended with the land counsel for the insurance company, the doctor's evidence is the limb disability is 45.69. Then in that case, the whole body disability will come to 15.23. The court had already taken the disability on the higher side and granted the compensation. In that view of the matter, this court finds no reasons to interfere. Accordingly dismissed. Next.
Till number 15.
What about this?
Anup Sitaram Rao. Rajan IS.
Only income, the quantum only.
So quantum?
Quantum.
Let's see.
Claimants also preferred an appeal.
That is also for enhancement.
Enhancement.
We will do this and both that it will come. Who is the counsel? Gopal Krishna.
No, my lord, Rajaram.
Rajan. Serial number 50.
Oh, Rajaram.
Rajaram S.
Shall we do or yes, Pradeep? Shall we do the calculation or?
Please, my lord. The date of accident is, my lord, 2020.
What is the connected number?
4762, my lord. 4762 of 24.
We'll do the calculation. We'll refer this to the Lok Adalat. If it works out, fine.
The income considered on 18,000, my lord, instead of 14,500.
Come to the table. How many are the injuries?
My lord, para 25, my lord.
Please read.
Cut lacerated wound over the left knee, abrasion, right knee, and cut lacerated wound at thigh.
4 injuries.
Four, my lord, fractures.
4 injuries.
No fractures, my lord. Cut lacerated wound, abrasion, and cut lacerated thigh, my lord.
Court has already granted 70,000.
70,000.
Yes, medical expenses as it is. 4,60,000. Then how many days he was in hospital?
13 days, ma'am.
30 days.
13 days.
13 days.
13 or 30?
13.
Then another 3,000 there. Then loss of income during which year is the accident?
2019.
It should be. What is the amount?
2020, my lord. 14,500. 14,500.
Where are they? 14,000?
500.
14,500 into 3. Into 4. It comes to 58,000. Then
Our main grievance is, my lord, income taken on 18,000.
uh,
Our main grievance is income considered by the MSCT at 18,000 per month. That should be 14,500.
then we will see.
Please.
Then on all the heads it will come down.
Please, that is also, my lord. Pain and suffering 70,000.
No, pain and suffering we can go. It can be maintained. Then loss of income during the treatment period, it is coming to 58,000. I think court had given for the lesser
54,000.
months. Now future income, what is the disability?
8%.
That's 14,500. What is the age? Age
39 years.
multiplier is?
Multiplier, my lord, 15.
Doctor's evidence itself is 8%.
No, my lord, 14.77%. Whole
Then why
body.
it is taken 8%?
Conclusion is that, my lord,
The
para 15, my lordship. May I read that?
petition fixed at 8%.
It is pertinent to note that the tribunal is not under the obligation to consider the percentage.
Before
of
that,
disability.
we'll go to the evidence of the doctor at page number.
Para 13, my lord, doctor evidence. PW doctor has deposed about the injuries sustained by the petitioner and the nature of inconvenience and loss of power of muscle stability, a component, mobility component, and range of motion.
So why not we take 15%? Anyhow, we are taking the income at that only. We'll take the disability at 15%. It comes to 3,91,500. What is granted? 2,60,000. So then loss of amenities not granted.
Not granted.
Loss of amenities Then for this disability, you are 30,000. So it's coming to 10,22,500 against the granted amount of 8,54,000. The insurance company and the claimant insurance company has filed MFA number 4762 of 2024.
2683 of 24 insurance company.
No, I'm a claimant's appeal.
Claimant's
Claimant has
appeal.
filed MFA number 4762 of 2024 and the insurance company has filed MFA number 2683 of 2024, questioning the quantum of questioning the compensation that is awarded by the tribunal. It is counsel appearing for the insurance company submits that they are ready to pay an amount of rupees 10,22,500 against the awarded compensation of an amount of rupees 8,54,000 for filing the compromise for filing the joint memo. List this matter before the local Adalat tomorrow along with this MFA 4762. Yes.
Cell number 16.
16, 17.
Inform him more.
18 Milord, liability.
Inform the other side also. Yes.
Seal number 16, this is a connected matter, my lord.
Huh?
This is a connected matter, my lord. Kindly it may be connected along with that.
On you are
Implication
before the
of-
court questioning the quantum.
Implication of driver, we are challenging liability.
Post along with so and so. Admit post of final hearing. Next.
Cell number 17.
17 also.
17 also, my lord.
Admit post of final
Connected
hearing.
matter, my lord.
Next 18.
18, it's also liability, self-fall.
Time for the respondent, there is a connected matter. MFA 6413 of.
What happened to his case the other day?
18.
By the time I was back, I couldn't.
So was it settled?
Which case?
Do you remember the other day one case of death? He said he'll find out from his senior and
Oh.
what happened to that?
One
Second?
to be posted on 26 November. Like, by the time I was back, actually the local was.
You remember that? One matter he wanted and we passed. What happened to that? Tomorrow? What, is it acceptable?
Like senior counsel, he will be there for the actually he will be there.
Yes. Post along with so and so. He was giving a number. Post along with so and so. Admit
MFA
post for final hearing.
MFA 6413 of 20.
Write on the paper and give next 20. No. Not this one.
Yes.
Yes, next.
Cell number 19.
Not 19.
For
20.
appellant, 19 Milord. 19.
No.
More appeal is pending, Milord. 5718 of 2024.
Dispensation, Lord.
All that.
R1. Dispensation to issuance of the notice to the R1, my lord.
In which case?
19, my lord. Maruti GB.
19 serial number.
Already Vakalat is filed for R1 and R2.
19 serial number 19, sir.
19.
First list.
Funds council, madam.
First list 19 serial number.
Yes.
Funds council press for time, madam.
Yes, next 20.
Cell number 20.
Yes.
Hearing for the appellant, my lord. My lord, I am before this honorable court being aggrieved by the judgment passed by the MACT, wherein the honorable tribunal, without even providing me a fair opportunity to file my written statement and even contest
You're the owner of the vehicle.
I am the owner of the vehicle, my lord.
Hmm.
And a judgment has been passed, my lord. My lord, the entire
When
matter,
was the judgment passed?
3rd July 2024, my lord. Incident was on 2019, my lord. My lord, the entire matter arises from a motor vehicle accident wherein the husband of respondent number 1, Mr.
No, there is still no stay is not granted.
No stay is granted, my lord.
Then deposit the amount.
My lord, we have good merits in the matter, my lord.
My merits will be decided when it comes, but you have to deposit 50% or else will not grant any.
My lord, one humble submission. The execution.
If you want stay only on deposit of the money. Otherwise, no. Get instructions from your client, pass over. Yes, 21.
Cell number 21.
In this case, I prefer the respondents 1 to 4, my lord. I filed Wakalat the day before yesterday. Even I don't have copy of the appeal.
Quantum?
Only quantum, my lord.
We'll
Other
calculate the quantum.
aspects I will not present to my lord. Only 6% interest may be made instead of 9%.
The insurance company has preferred this appeal, questioning the quantum of compensation and the interest that is granted at 9%.
9%.
9%. Land counsel for the respondent submits that the court had rightly granted the compensation and there are no grounds to interfere. Having heard so and so, this court has perused the order passed by the tribunal and the tribunal had granted the compensation as a granted a just and reasonable compensation and there are no grounds to interfere. However, as far as the interest is concerned, the same is reduced from 9% to 6%. Accordingly, the appeal is partly allowed, reducing the compensation from
Amount in deposit may be transferred.
9% to 6%. Amount in deposit shall be forthwith. No, why not the amount be deposited before the MSCT? Why in every case? Why this procedure to be undertaken? Pradeep?
Some of the judges, my lord, will
No, this as a matter of procedure, I'm thinking
It's
if it
correct,
is
my lord, but
deposited before
some of the cases,
MSCT.
my lord, what has happened, my lord? We have deposited before the MSCT without taking permission from this court. Some of the cases they have withdrawn the amount. Wherever the
How the
involvement
court
of
will
the
grant the permission?
without
Listen until.
please, my lord, several
No.
cases it has been happened, my lord.
No. If there is a stay order by this court, they will not do
That
it.
too, MSCT has released the amount. My lord. In my case, only 3 cases they have withdrawn.
That's why it is deposited before this court.
That's a major drawback.
Yes, next. Amount in deposit shall be transferred. 22.
22 and Srikant Rao.
Insurance company challenging the liability.
Liability, notice, and the stay petition is there.
State. There is
Liability
no,
on what is the ground?
There was no registration at all at the time of accident. Only 1 month registration was it was expired. After 6 months, the accident occurred. There was no
So
registration.
in that case, pay and recovery.
That should have been done. That is not done.
So what we do is 50% you deposit, let them withdraw. The same stay on the condition that it is submitted that they are on the question of liability before this court. Considering the submission, they shall be stay of all further proceedings on the condition that they deposit 50% of the amount and they respond within 6 days, 6 months, 6 weeks. And on such deposit, the respondent is at liberty to withdraw. Yes, next.
Cell number
23.
23. Vijeta Nayak.
My lords,
For appellant.
this is a case where case of injury where 1 lakh amount as a
This is
global
appeal
compensation.
by whom?
Appeal by the petitioner, claimant.
Then for enhancement notice.
Cell number 24.
Which is the insurance company?
Gen 1 sec. United India Insurance Company Limited, your lordship.
Who appears?
United India.
You appear? Yes, Your Lordship. So Geeta Raj is directed to take note.
Manjula Tejasvi.
Manjula Tejasvi. So he's
R1, my lords, is appeal against R1 is dismissed. The petition against R1 is dismissed since he's the driver. R2 and R3 are have contested the matter before the lower court. So we'll file a dispensation memo to that regard.
Give it.
Well,
Write and give it.
Please.
The note so and so is directed to take notice on behalf of the respondent number 3 insurance company for R2.
R1 and R.
For a memo is filed seeking dispensation of notice to R1 and R2.
R1, my lords. R2 has contested the matter. It is jointly liable.
Liability is on them or not?
It's jointly liable, my lords.
So R1 and R2, you can ask for dispensation.
Please.
Write a memo and give to them. Yes, next.
Cell number 24.
Your Lordship, insurance company is in appeal,
Tejasvi.
challenging the liability, Your Lordship. Even the
Manjula name Chandra Tejasvi.
Lordship company is challenging the liability on the ground that the vehicle was not at all involved. Even the insured also appeared before the court. He has given the evidence and he has even filed the PCR also, indicating that, I mean, to the contending that this vehicle was not involved.
It is submitted that the insurance company is before this court on the ground of liability and that the vehicle is not involved in the accident. And they shall be stay
After 8 months, they have given notice to the insured.
Call for the proceedings on the condition that they shall deposit 50% of the amount within 6 weeks, and on such deposit, on furnishing the security, the claimant is at liberty to withdraw the 25% of the amount, which is subject to the result of the writ petition,
Obliged.
the appeal.
Obliged.
Yes, next.
Notice to respond. Serial number 29, 25.
Yes, 25.
This appeal, this writ petition, I agree with the father who is seeking for an order to visit his daughter. Lord, what has happened is that vide an order dated 3/9/2022, the family court had granted me visitation on Saturdays and Sundays at the visitation center, although the parties reside not even 1 kilometer apart in Hebal. Vide the impugned order. That visitation of Saturday and Sunday, which is 8 times a month, has been reduced to 2 times a month. It is against that impugned order that I am before this honorable court.
In order to see more progress and development in the relationship with the minor child, this court requests the land counsel for both parties to draw up a memo, either by way of a joint memo or a separate memo, to explore the possibility of settlement with regard to some kind of custody visitation to the father and the mother, and some payment of educational expenses with the father. So also the custody and visitation rights to the non-custodial parent. On the next date of hearing, land counsel for parties shall suggest a more conducive place for the child to spend time with her father, either some park or play area rather than the child visitation center at Karnataka Mediation Center. Now, what is the age of the child?
11 years, madam.
11 years. What is the order of the family court?
The order of the family court, the 3/9/2022 order was every Saturday and Sunday. But now it is now reduced
Saturday
to
and Sunday?
of every week
No. Where?
at
What
the
is
visitation center from 10 a.m. to 6 p.m.
Visitation from 10 a.m. to
6 p.m. on Saturdays and in a mall
on Sundays.
on Sundays. Now that visitation was frustrated by the respondent here in wife, who was always present all the time, even though the visitation order did not call for supervised visitation. Those photographs I have also produced in the writ petition. Now what happens?
The boy,
Girl child, my lord.
girl child.
So their
When
contentions,
they are separated,
they have been separated from 2021.
till 2021, the girl.
She was with me even after 2021 when the divorce petition was filed. Also, she has been sent to my house for 3 days. That is all suppressed before the family court, and never mind. Now the child has been examined in chambers also, and she says that she has no problem even being with the father. She has absolutely a normal relationship.
What are you suggesting now?
Lord, I had asked for weekend visitation so that she can spend more time with me.
Weekend is in the daytime.
In the day, overnight visitation, my lord, and their contention is that there is no woman in my house for her to relate to, but my mother resides with me. As a matter of fact, the child,
The distance between both your houses is about
1 kilometer. And as a matter of fact, in her sworn affidavit itself, the respondent wife says that she works from 2 p.m. to 10 p.m. To 11 p.m. every day. She comes home only post midnight. So actually my daughter is left all alone on most days, on most working days. There is nobody to supervise her. The respondent wife here and says in her statement of objection, the lordship will see that she says that she wants the child is being supervised by a 90-year-old father. She has no mother. Her mother passed away 2 or 3 years ago. She is supervised by a live-in maid, and she wants this child to have a relationship with that woman, with her cousin who's 15 years, who lives somewhere close by. But she must have no relationship with the father or with the father's family. As a matter of fact, when my sister had visited Bangalore from the United States, and I had taken my mother and my sister to the mall to meet my daughter, she said there is no order of visitation for them. If they don't go away, I will walk away from here with the child. This is the sort of alienation that I am facing on a weekly basis. Now the impugned order reduces my visitation, even this meager visitation of weekend from 10 a.m. to 6 p.m. visitation. It reduces it to once every 2 weeks, 1 day every 2 weeks.
Yes, what is
If I may be permitted to represent the correct facts, on 3/9/2020, an order was passed by the Honorable Family Court based on their application, where they had asked for overnight custody from Friday to Saturday. The Honorable Family Court passed an order stating that the father could visit the child every Saturday and every Sunday. Now, my lord, after 3 months of having filed that application on, and they haven't challenged that order because they'd asked for overnight custody and what was granted was every Saturday and Sunday. After 3 months, they have filed a similar application. The only difference being that in the previous application, they asked from Friday to Sunday. In the subsequent application, they asked from Saturday to Sunday. So virtually they've asked for the same relief. My lord, what I would like to mention is that for 2 years, we continued with this visitation on every Saturday and Sunday. We have not made any attempts to alienate, and neither had we challenged the order of 3/9/2022, or nor have they challenged the order. But during these visitations, we in fact have filed another application. We also filed an application after 2 years seeking modification, stating that every Saturday and Sunday was also difficult for the child because the child did not have time to spend with her other friends, other activities. We did not ask for a complete cancellation of all visitation. That is not true at all, that we've been trying to alienate the father. And also our submission was that during these visitations, the father was bullying the child, was pulling her leg. It was not very pleasant, my lord. And the third submission was that since the mother is also working, we are not able to spend time during weekends, for which their suggestion
will do something like this.
My lord,
now you're working like as you said, from evening 6 o'clock, 4 o'clock to 11 o'clock. That's your shift or schedule. So let the father have the overnight custody. You have the, because in the ensuing vacation, let the father have the custody.
My lord,
from 4 o'clock to next day morning. Let him send to your house by 7 o'clock or 8
my lord,
o'clock.
the child is not comfortable spending overnight for the father. But if I may be further permitted to continue, before the coordinate bench, the learned judge had advised us to make attempts to settle the matter. In fact, that was also done. And during the vacation, we have sent out an email on their request to give them some additional days during vacation time, which we have done. Now, what has happened is we have sent out that email, and also because the learned judge had advised the father to make some payment towards educational expenses for the child.
No, before that, let us. No, when you're not at home, why
But,
you
but my lord, my lord, my lord, my lord, my lord, it is not fair that a working mother who's not paid any maintenance, we haven't even asked for maintenance, to be fair, nor have we asked for any expenses for the child.
But still I have
because
paid.
because we have had abusive relationship. But my lord, the father doesn't contribute anything. I have no choice, but I have to work. Their suggestion is that we will keep the child and drop the child back at 12 midnight when the mother returns. Now the child is not being left alone with a 90-year-old father. We have a live-in help who looks after the child. My lord, just because I'm working doesn't mean that the father is entitled to overnight custody, my lord. The child is
all right. It is all right that the girl stays with the maid at home, but not with the father.
Yes, my lord, because we have even extracted conversations between the father and the child. I could take my lord through those conversations where he not only puts down the mother and her family members, but he is harassing the child. But be that as it may, we had because they had requested for additional days during vacation, we had sent out an email. In fact, we had also agreed to the alternate places instead of the visitation center. We had agreed to the alternate place.
What will happen if he takes her to his house?
My lord, the child is not comfortable to go. We have absolutely no objections to the father taking the child to other
she's on
play
vacation
areas.
now.
Please, my lord.
So this weekend, let us see what will happen. Then we'll have it on Monday.
But my lord,
Right.
the child is not. My lord, let him take
Your
the
lordship
child.
will just see on page number 156 what is the alienation. Your lordship will remember this case because your lordship passed an order in this case where they alleged that the child was not his, and the method by which she got pregnant was fantastic. Page number 156, your
My
lordship's
lord,
order.
we haven't challenged that order, so it is irrelevant, right?
Page number 156, my lord.
My lord, then I also may be permitted to take my lord through my submissions as well, my lord. Because we haven't
Number
challenged the
156,
said order.
running page number 158 was an application that she moved before the trial court, before the family court, seeking an amendment in pleadings after an order of visitation had been passed.
150?
158 is in bolded is the insertion that she wanted in a petition for dissolution of marriage. At paragraph number 19B is what your lordship will remember. This is the level to which she will descend to alienate me from my daughter.
Paragraph number?
19B on page number 158.
158.
8, yes.
19A.
19A and below that 19B. It is most relevant to state. Last 4 lines. And even after this order is passed in the writ petition, in her application, in her affidavit, she still says you are not the father.
That is not true, my lord.
It is there in the
That's
pleadings. I will point it out,
absolutely
my lord.
false.
It
In
is
fact,
very
if I
much
may
so.
point out, in their objections which they had filed in 2022, which was at the same time that the amendment application came to be filed, in objections to the modification IA, that particular submission had been made because the amendment application was still pending. But in our subsequent application for modification, we have absolutely not made any reference to whatever submissions have been made in the amendment application, as the same came to be rejected, and we have not challenged it. In fact, the previous counsel on record had also filed an application seeking for DNA test for the child. These applications have been withdrawn, my lord. We are not pressing on it at all, but
Please come.
Kindly turn to page number 210, my lord.
What is the contribution of the father?
Zero.
My lord, he had paid a sum of rupees 1,25,000 towards the school fees without anybody asking, without an application being made. Subsequently,
22, they are residing separately from
2022, my lord.
2022. We are in 2025.
We're 2025. In 2022, he paid 1.25
For the
lakhs.
school expenses of the child.
my lord, the annual school fee is rupees
2 lakhs, my lord.
2,70,600.
2 lakh?
70,600, my lord.
Now that is
No.
this year.
1 lakh, at least half of it.
Ready?
No, half of it come to 1,30,000.
Yes.
So, you have already paid how much?
1,20,000 we had paid.
So
Let bygones be bygones.
So, then for 22, that is 23, 24, 25. So it would come to
3 lakhs.
no,
A lakh here.
More
It's
than
1,35,300.
3 lakhs, 3,90,000 it would be. It would be 3,90,000. So 3,90,000 is the fees.
Yes.
Then what about she requires a basic.
My lord, she has not made any application because her salary is 3 times my salary. But never mind.
That's not true, my
But never mind. They have not filed any application because her statement of assets and
I
liabilities
admit
would
that.
have to be exposed.
So, no.
So now if it's a
Without
matter
going
of
into-
school
without-
fees.
Without going into that aspect.
Yes.
As far as this 3,90,000 is concerned,
Yes.
what is the take of your client on
4,05,000. My calculation for the half of the school fees is 1,35,300. For 3 years, it will be 4,05,000.
His take home salary is 1,75,000.
Lakh and 75,000.
1,75,000.
So no, he is ready to bear the half of the educational
Yes.
expenses of the child.
Yes.
Now, half of that, according to her calculation, it will come to
4,05,900.
4,05,000.
Yes.
So this amount, when he is ready to pay,
Not give us 4 months time. We'll pay 1 lakh every month. Because
in
it's over 4 years. They ought to have asked, they ought to have, let's
So-
be fair.
So in the next 4 months, you are ready to pay
Yes.
a lakh a month, so
Yes.
4 installments.
Yes.
That is one aspect. Now coming to now what we do is, like today is Friday.
Yes.
Saturday and Sunday, we make some arrangement. We'll just find out how is it happening. We'll meet the girl on Monday and accordingly we'll take it forward.
My lord, please, as I've been submitting, we are not attempting to make parental alienation at all. My lord, my only request is if it could be.
Meeting, when both of you are staying just a kilometer apart, going to the malls.
No,
going
I
to the
agree.
medical-
I absolutely agree with it. The
Yes.
child visitation center is not an ideal place at all.
Even the mall also.
Even the mall, my lord. I have no objections to that. In fact, what I would like to point out is, I had sent out an email to them agreeing to their places. We had thought of some play areas which is close to the house.
She has
My
sent
lord,
an email.
please,
She has
please,
sent an
please
email.
let me
Kindly see the
complete.
email for yourself.
Do not produce that
Kindly see
email.
the
It is
email.
without prejudice email
Whatever.
you're producing in court.
You did not say so.
I have mentioned it. How unfair
Kindly
is
see
it?
the email.
How
Kindly see the
unfair is
email,
it
my
that
lord.
you asked me to send an email in response to your request and you're producing it in court?
My lord, kindly
My
see the
lord,
email.
my
The email
submission
says
is
that
if
she will
stop-
be in the vicinity. She will be in the vicinity. This is a super, it says so in the
My
middle of the
lord,
day.
it's
As of
first
now, the
of
mother
all
will
quite
drop and collect the
unfair.
child from the agreed visitation point venue Upon my instruction, she has agreed not to tag along with the father and the
Unprofessional, I
child.
should say.
However, please be informed that she will be in the vicinity. What she was doing on page number 132 onwards, your lordship will see on page number 132, sitting in the visitation center, she will continue to do. Where is the visitation that I have with my daughter? How am I supposed to establish any modicum of a relationship with my daughter? The child has been in her exclusive custody for 4 years, and still she says that I'm not supposed to meet my daughter. 4 years.
My lord, I had sent them out an email. If they had any objections to it, they should have come up with a counter offer. Instead they produced. My lord,
It's like you don't want to send an email that which has to be secretly kept within. What is the great objection for that?
my lord,
As for the court
my
orders, you
lord, my
sent it.
submission is I had sent this email out before this previous Saturday. They had a visitation. They have not responded. In fact, the mother has sent out another email to him saying that I have mentioned these other places. Kindly, since you have not responded,
Since you
I will
have
bring
not
that.
responded
Please
to
don't
the
keep
email.
interrupting, sir.
Since you have not
My
responded
lord,
to the
my
email.
lord, if counsel keeps interrupting, I'm not allowed to make my
This is the
submission.
whole difficulty in these family matters. All the councils are fighting like more than the.
I also agree with it, my lord. In fact, in family court also, it's the same way.
No, that's what, but
But my lord, I may be permitted to complete my
it shouldn't be.
submission. I'm being constantly interrupted. My only submission is we have agreed to these alternate places. On the last date of hearing, they have not gotten back to us saying that we will meet in so and so play area.
Saturday and Sunday, the girl will go to the father's place from.
My lord, let it be
10 o'clock,
gradual.
10 o'clock to 6 o'clock.
My lord, let
And,
it be gradual.
If required, we will meet the girl on Monday, then we'll pass further on.
My lord, my only request is let him take the child to a play area. We have absolutely no objections. In fact, I will also advise the client
What
not
will
to go
happen
there.
according to you if they takes her to his house?
My lord, the child is not let it be gradual, my lord. The child, in fact, before the trial court also, if I make a submission, the order for modification was after meeting.
In
After
all the
meeting the
family
child.
matters, we are observing it. This gradually will never happen.
My lord, but even the Honorable Family Court had passed the order after meeting the child. It was not an order passed without consulting the child. It was passed after meeting the child. It's even recorded in
No,
the order.
your presence is not there.
No, we will not be there.
Please listen to the court. Your presence is not there. No, how does it matter whether it is a play area or a
Let
or
it be a
his house?
public place, my lord.
What he'll do?
My lord, we're just more comfortable because the child is also insisting the child will spend some time in a public area. They have activities that they can do together.
He will take for a long period of time. What they will do on the public place? Why are you not?
My lord, it's a play area, my lord.
My lord,
So
she
the
can
girl
play
will
from 10 a.m. to
the
6
girl
p.m.
will play. The father will watch.
No, but that is their submission, my lord. They have said that the father will have.
Yes. Please come.
My lord, it's unfair that overnight is being granted, my lord. Then I may be heard on merits.
Where the overnight is granted?
My lord just indicated that Saturday.
10 o'clock to 6 o'clock, I said.
My apologies.
You can't presume and I know.
My lord, because my lord indicated
You
weekend.
have to be with the open mind. Court do understand.
I understand, my lord, but at the end of the day, I'm also representing my client, my lord.
Heard the learned counsel appearing for the petitioner, mother and the respondent father. It is submitted that by the learned counsel appearing for the mother that both of them are staying within the vicinity and their houses are situated a kilometer apart, and they have to go to the malls and to the mediation center for visitation. The girl, they were residing together until 2022, and from last 4 years, from 2022 to till now, the father had no sufficient interaction with the mother. According to them, though there is no order for a supervised visitation, still the mother was present whenever he was exercising the visitation, and the visitation was never comfortable. According to him, the mother works, her work is from 11 o'clock, 4 o'clock to 11 o'clock.
2 p.m. to 11 p.m.
2 p.m. to 11 p.m. and she is taken care of by an aged grandfather and a maid. It is submitted that he is staying along with his mother, and he has also filed the Aadhaar card and other particulars to show that his mother is staying with him. And if the overnight custody is given to the father, he would be able to develop bonding with the daughter. Next one. Learned counsel appearing for the respondent submits that. The respondent mother submits that father had not contributed anything towards the welfare of the child, towards the expenses of the child. And when he is not aware of the duties, but he is very much fighting for the rights, it is submitted that as she's working overnight, she's working between 2 and 11 to take care of the child, and that cannot, and on that ground, he cannot seek for the overnight custody. It is submitted that the girl is not comfortable to stay overnight with the father, and 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 the visitation and the bonding has to be gradual, and it cannot be imposed on the girl straight away, making her to stay overnight. Overnight. It is submitted that the order that is passed by the tribunal, passed by the family court, is a well-considered order, and at this juncture, no interference is required. Next paragraph. Having heard the council's peruse the earlier orders passed by court and bench of this court, and also the material placed on record. The undisputed facts were that the parties are staying separately from 2022, and their houses are situated within a kilometer from the other. The girl is aged about 11 years. The father is staying along with his mother, and the mother is staying along with her father and a maid. The visitation at a public place, at a play area, and at a mediation center can never achieve the purpose for which the visitation is granted. When the visitation is at a play area, the child will be playing, and there will not be, the father may not be able to have a conversation, and in the process develop the bonding with the daughter. Considering all these facts, this court deems it appropriate to grant the visitation between 10 o'clock to 6 o'clock to the father on Saturday and on Sunday, that is 26th and 27th of April. How the custody will be?
My lord, another request.
We'll pick
Mother
her
will
up.
hand over the custody
Mother
of the
will
child.
hand over the custody of the
I only have
daughter,
another request.
and mother will hand over the custody of the father to the father, and again you will pick up.
We'll pick up.
And at 6 o'clock, she'll pick up the. You won't be there. You will be there
Where, my lord?
to pick the child at 6 o'clock.
Yes, my lord.
The mother will pick up the child at 6 o'clock. Yes.
My lord, my only request is, I'm not aware on which particular Saturdays and Sundays, but the child has swimming and taekwondo classes. My only request is that if it falls on 26th and 27th, the father may kindly take the child for these classes.
If on the particular
Gives us the schedule,
if on
I'll
the
abide by the
particular
schedule.
day the girl is having any other activities, the father will accompany her to the said activities. Next, with regard to the the school fees and the maintenance of the girl is concerned, the father submits that the wife is earning 3 times than what the father is earning, which is denied by the legal counsel appearing for the respondent mother. He submits that he is ready to bear half of the school expenses of the child, and he has already paid an amount of rupees 1,20,000. And it is an admitted fact from 2022, that is 22, 23, 24, 25. The 4 academic years, the mother is paying the school fees. In that 1,20,000 is paid. And for the remaining 3 years, as per the counsel for the respondent, half of the fee would come to
4,05,900.
4,05,900. father is present before the court and on instructions from the father, learned counsel appearing for the father submits that the father will paying the 4 lakhs in in 4 months. That is
4
1
equal
lakh,
installments.
4 installments, 1 lakh each installment, and the first installment would be on Sunday,
Sunday, how will pay on Sunday?
Saturday or Sunday, whenever
Pay
it
it
is.
on Monday. I
On
think
Monday.
second,
You will be meeting them on Saturday or Sunday. That day you can hand over whatever.
I'll give a check on that day.
On Sunday.
But
On
she has-
Saturday or Sunday when he was
Then they
when
can
he-
give
when
us
he is
the-
exercising the visitation. And exactly 30 days after that, he will be paying the next one, and accordingly the other 2 installments also.
Party may kindly be restrained from speaking ill about the mother and a
Lord,
family
this goes on,
members.
this has been going on. They have the child for 4 years.
Neither the father nor the mother shall discuss with the child either with regard to either of them, and they should, it's a responsibility of the both parents to see that the visitation goes on smoothly. Next,
Lord, this matter will be listed on Monday.
on Monday, list on Monday.
My lord, is the child to be kept present on Monday then?
If you want, if there are anything which you want to bring to the notice of the court, then if everything is going fine, then let it go on. If the child has any difficulty, she shall be present before the court on Monday, otherwise not required. Yes, next.
So number final hearing matters.
I pray for an accommodation after the vacation because
26.
the connected matters got dismissed in the Andhra
After
Pradesh High
admit-
Court.
No, it's already final hearing, post after vacation.
Yes, it is highly applies.
Yes, what about next, Pradeep?
Damages, my lord, damages.
Can we settle?
Maybe settled, my lord. I have given one figure more.
Kindly,
What
Not
he is
agreed.
asking, what you are ready?
kindly
Not
see para
agreed.
25, my lordship may suggest, I will agree.
Give the file.
Please. There are 22 marble slabs are damaged, my lord.
We'll see what 25 refers to.
Exhibit P3 is a major matter in Canada, my lord.
1
It
minute.
states that
25.
25.
Read it.
In order to prove that the petitioner have purchased the stored granite slabs, have produced the eBay bill marked at exhibit P9, and perusal of exhibit P9 disclosed that eBay bill generated on 23/6/2019 and stated that the valid up to 26/6/2019. The bill is issued by Varsha Granite, Harapnalli Village, Anekal Taluk, and issued in the name of Dr. Lakshmi Rajshekar, that is the petition number 1. Further details of quality of granites, value of the genuine mentioned exhibit P9, this bill dated 23/6/2019. The date of accident is 3/11/2018.
Date of accident is?
3/11/2018.
Then it is 23/6/2019.
Subsequent to the accident.
is
That's
not
what the
disbelieved,
MSCT has disbelieved the
bills.
but
And
and granted
fact-
50,000 global compensation.
Fact remains that, my lord, there are 22 slabs are damaged. I have produced the photographs and the exhibit P3 is the major.
Those slabs, those bills are subsequent to the accident. How are they concerned with the accident?
Oh, my lord, when we lost the bills,
Why
my
should
lord.
the court, no, why should the court believe all that? That it is something which you had it before the accident?
22 slabs, cost of the 22 slabs, my lord, with some amount. He knows very well, my lord. Recently constructed the house, my lord. You know what is the value of the cost.
Even
But-
on the merits of it also, you will not get any order. That's why, how much you are ready for the,
50,000 has already granted, my lord. I suggest, my lord, friend, another 50,000 will going to grant.
Oh, my lord, the labor cost, I have examined one.
all those things will come,
Please, my lord.
provided court believes that those were purchased prior to the accident.
I understood,
You do
my lord.
not have any material that you have purchased it before the accident, isn't it?
I don't have that bills, my lord. Later it was taken from the company, my lord. They issued a bill, e-bill, my lord. Kindly see that the exhibit, the bills, my lord.
Whom you
Everything-
examined,
Please, my lord.
whom you examined?
I
to-
examined one surveyor, my lord, not
Not the
the,
surveyor, about the, no, the issue is
No,
with
no,
regard to the slabs.
not examined.
then be happy with it, or else I have to dismiss it.
I am saying that, my lord, there is a 22 slabs, my lord. The cost of the marbles, your lordship are aware that.
Mr. Counsel, we are on a legal
Please, my
point.
lord.
We are on a legal point.
We are discussing,
We
my
have
lord,
to-
on
No,
Lok
that's what I'm
Adalat,
saying.
madam, even though.
Now, list this matter before the Lok Adalat on 26th. It is submitted by the insurance company that they are ready to pay an amount of rupees 50,000 over and above what has been awarded by the tribunal. If it is, if there is no settlement on that day and joint memo is not filed, is this matter on Monday?
26.
Yes.
Then number
26, if I'm not
28.
settled, 28 it will be listed.
Alesha
We have taken up
Arji,
28, my lord. Tomorrow I am.
26.
28, Monday.
Lok Adalat is there on that day, that's fine.
Continuous session on tomorrow. Maybe take on Monday. I will discuss with the Pradeep.
Anyhow, we will have a Lok Adalat on 28th also.
Please.
28th in the Lok Adalat. If it is not, then list the matter on 2nd.
Please.
Yes. No, Lok Adalat on 28th, then the court. Yes, 28th.
Then number 28, Alesha Arji,
Enhancement.
Anup Taram Rao.
The pay and recovery order has been passed.
Already passed.
Already passed. Already.
It's all in Kannada.
It's entire
The court,
it's already settled for 2,75,000 before the local.
will record that.
2,75,000. But
Who settled?
Ask Anup Sitaram.
Shivanna Gowda appeared.
Uh-huh.
We company advocate Shivanna Gowda and Madam had discussed it. It has settled for 2,75,000 subject to the approval of the.
Subject to the? No, look
Subject
at
to the
it.
approval of the office.
Password. Discuss with them. We'll see.
Then number 29, Pradeep B. Manjunath Rao.
Pilford?
Appearing for the appellant in this case, my lord, challenging the quantum of compensation.
Then let's see.
Last occasion, my lordship had some time.
Hmm.
He was aged about 74 years, my lord, deceased.
Hmm.
The son was 56 years and 50 years. It was a major.
Hmm.
My lordship is referring to the Seemarani case.
Hmm.
I said, my lord, in this particular case, he was 74-year-old.
Simarani will not
15,000
apply a
income
case
as
of-
considered, my lord, 74 years old.
Then what was loss of dependency was granted?
Granted, my lord, 1/3 deducted, my lord, instead of at least, my lord, 50%.
No, if we do it that now,
Please,
but
my lord.
still, no, which year is the accident?
The accident is, my lord, 2021, income taken 15,000, my lord.
15,000. So according to you, half should be deducted.
Please,
Then it comes to 7,500.
please,
Into 12 into
5, my lord.
5.
5.
It comes to It comes to 4,50,000.
Instead of 6 lakhs, my lord.
How many are the
That has been granted, my lord, 1,10,000
is granted?
granted. Only this is the only amount
So
disputing.
how much
my lord.
is going? It is going to
1,50,000 reduction. If he has not ever aged about 74 years, my lord, will not proceed in this case.
We'll dispose it off on Monday.
Please.
No representation for the respondent. List is matter on Monday.
So number 30, B.C. Shivanna Gowda,
What about this?
Prakash M.H.
Admit, this is already in file hearing. Yes, list after vacation. What do you say? Any point or can be order can be passed? Huh? Then in that case, you're not entitled. Gratitude is passed. The insurance company is not liable. It is for the owner to pay the compensation. We'll pass orders. Simple case. Why should give that? Agreed with the award passed in MBC number 48 of 2021. Stated 5th March 2024. Insurance company is before this court. The claim petition is filed seeking compensation of an amount of rupees 47,40,000 for the injuries sustained by the claimant in the accident. The tribunal, by order impugned, had granted the compensation of an amount of rupees 1,10,147. It is a case of the claimant that on 30/3/2019 at about 4:30 a.m. she was traveling in an HO vehicle bearing registration number KA 18A9401 along with her orchestra equipments on Shikaripura Shilakopa Road opposite to Kutrali Farm. The driver of the vehicle drove the same in a rash and negligent manner and dashed to the roadside cement pillar, causing the accident. It is a case of the insurance company that it is a goods vehicle. No, she is not the owner of the goods.
She's the owner.
Why can't it be considered like that?
No, she is not. There are other passengers. Along with her, there are other passengers. Owner of the vehicle is also proceeding on that vehicle. But she is not the owner of the vehicle.
No, she is with the orchestra.
No, she was with, she is a singer. Owner of the orchestra was
It's
present.
also traveling. It is as it's a goods vehicle, as the claimant is traveling in a goods vehicle and is a gratuitous passenger. In the light of the law laid down by the Honorable Apex Court in Baljit Kaur, the insurance company is not liable to pay the compensation. The tribunal has held that the insurance company is liable on the ground that there is an insurance policy and the policy was imposed as on the date of the accident. And the court had relied on the judgment of the Apex Court. New India Assurance Company Limited with Rajendra Singh and others. And also court had considered the judgment of National Insurance Company Limited versus P. Sinita. The material on record discloses that she was traveling in the vehicle as a owner of the orchestra goods, as an agent of the owner of the said orchestra goods, as such the insurance company is liable to pay the compensation. Next para. Then counsel appearing for the insurance company submits that she is a singer in the said troupe and the owner of the goods is already traveling in the seat. So the finding of the tribunal that she is the owner of the goods is contrary to the evidence available on record. And once she is she's a singer and traveling in the said goods vehicle. She is a gratuitous passenger and the insurance company is not liable to pay the compensation. Land counsel appearing for the respondent submits that the court had rightly considered the evidence and passed the order holding the insurance company liable. Next para. Having heard the counsels on either side, peruse the material on record. There is no dispute about the fact the owner of the goods, the owner of the said orchestra is also traveling in the said vehicle. In those circumstances, the claimant cannot be termed as a owner of the goods. And once she is not the owner of the goods, and she's traveling in a goods vehicle as a gratuitous passenger in the light of the settled law, the insurance company is not able to pay the compensation for a gratuitous passenger and its owner alone is liable to pay the compensation. Accordingly, the appeal of the insurance company is allowed, holding that the insurance company is not liable, but the owner alone is liable to pay the compensation. The amount in deposit, the insurance company is at liberty to withdraw. Next. We'll complete this and then go.
List number 2. Serial number 1. Further matters B.C. Shivannagowda.
This case I appeal for it. Insurance company appeal challenging the liability and the quantum. But as per the complaint, is last date of hearing, I have addressed the argument, they are not present.
That's what it is. What is that? What are the grounds?
But the date of, according to him, on 5:30, he has met with an accident on 11/4/2007. we produced the MLC record from the hospital where it indicate that my lord, he was admitted to the hospital on that day at 9:30 a.m. Therefore, the
No, but
injury
the accident has taken place at 5:30.
5:30 according to him. He has lodged the complaint after 2 days. He said that by 5:30 and 11th, the particular day he has met with an accident and admitted. Thereafter, we have obtained the MLC from the hospital record where said that he has admitted in the hospital at 9 a.m. Therefore, that he is not sustained the injury in the course of his employment.
And what about the police records say?
5:30
Accident at 5:30.
5:30. Issue also in the very same whether petition approved 11/4/2007 at 5:30 p.m. he went to near so and so Malavalli so and so and so moved. Your lordship kindly see the document which is marked MLC record which was marked before the court. It indicate 9:30 itself he is admitted in the hospital, but the person
So
was
what is the reason for such admission?
Please.
As per the MLC?
Since police have filed a charge sheet, therefore company is liable to pay.
No. MLC says he was admitted in the hospital.
Please.
And, how he has sustained injuries?
Met with an accident, the injury, how the accident was now occurred, it was not disclosed. But
What it discloses, pass on that, take that.
injured person is Boregowda.
Hmm.
First entry, my lord.
35 years, male,
Please.
9 a.m.
Please.
Now, what are the other medical documents apart from this?
There is no other document.
Discharge summary.
Discharge summary, all my lord he said, but there is no dispute regarding the time in which he said that he is in the course of he is an employee. He is in the course of employment, he has sustained injury. He says at 5:30, but prior to that he is in the hospital. Question of the involvement of the vehicle at 5:30 does not arise. According to this document, my lord, if he is sustained injury at 5:30,
Then did he examine anybody from the hospital?
no, except this man.
And what is his case when you have put forth this? And how the court had considered it? Give it to
Court
me.
has not considered that, my lord. The other point, if it is not accepted,
Let's see the finding of the court.
please. This was not discussed at all.
And in this case, we will remand it.
That is better.
It's better. You will also get an opportunity.
Please.
The agreed by the orders passed in is here number 51 of 2024, dated 16th August 2016. The insurance company is before this court. The claim petition is filed seeking compensation of an amount of ₹4 lakhs for the injuries sustained by the claimant during the course of the employment. It is this case that the claimant is working as a loader and unloader. And on 11/4/2007 at around 5:30 p.m. as per the directions of the owner, he was unloading the cement loads from the lorry, and at that time the driver of the lorry moved the lorry in a rash and negligent manner, thereby cement bags fell from the lorry on the part of the legs of the claimant, thereby he sustained grievous injuries. He was inpatient in the hospital and suffered fractures on both bones of the right leg. Thereby surgery was conducted by implanting the rod on 30/4/2007. And he has spent not less than 50,000 towards medical expenses. The tribunal had granted an amount of rupees 1,47,795. Next para. When counsel appearing for the insurance company submits that on their behalf, Where is the document? MLC.
Your para 13 may kindly please.
Huh?
Para 13.
Not para 13, exhibits I am saying.
That's what exhibit R P26 extract accident registered of district hospital Mandya, where it is clearly mentioned 11/4/2000.
P26, exhibit, when council submits that accident register extract shows that exhibit P26 that accident had taken place at 9 a.m. and he was admitted in the hospital at 9 a.m. As per the other records, the accident had taken place at 5:30 p.m. It is a contention of the counsel for the insurance company that the accident had not happened during the course of employment, and even prior to the accident, he was admitted in the hospital. When the accident had not happened in the course of employment, the insurance company is not liable to pay the compensation. It is submitted that when exhibit P26 is already marked, when this contention is raised on behalf of the insurance company, the same was not considered. Next para. On the last occasion, there was no representation on behalf of the respondents. Hence, this matter, having heard the counsel for the appellant, the matter was directed to be listed today under the caption Part 3. Today also, there is no representation on behalf of the respondent. Hence, this is an appeal of 2016. This court is proceeding to pass the order on the merits of the matter. Next para. Having heard the line counsel for the respondent, peruse the material, appellant, peruse the material on record. Exhibit P26 is the accident register extract, which is filed by the claimant. That shows the accident is he is admitted at 9 o'clock, and all other documents shows that the accident happened at 5:30 p.m. In those circumstances, this court feels that there is force in the argument of the learned counsel appearing for the insurance company, and nobody is examined in support of the said document, and even the order is silent, and there is no discussion in the order with regard to this document. In these circumstances, this court deems it appropriate to remand the matter so that both the parties would get an opportunity to put forth their case, and the court would be able to give a finding on the same. Accordingly, the order dated so and so is set aside, and the matter is remanded to the trial court. The amount in deposit shall be kept in a FT, shall be transferred to the trial court and shall be kept in a FT. Yes.
Open all the grounds.
All the contentions are open for the parties, and the tribunal shall dispose of the same within a period of 6 months from the date of receipt of the copy of the order. Yes, next.
Question number 2. Yes, Hemant Bharadwaj.
Lord, I appear for the petitioner father.
For the respondent, my lord. For the mother, my lord.
Yes.
Your lord directed the Enhancements to file its report by today. Lord, it
Is
says
there-
the Enhancements report is still awaited. May I request, my lord, for this to be taken up either on Monday or Tuesday.
Report is there before the court.
The cause list indicates what was awaited.
It is there.
My lord, kindly pass over, my lord, 2:30. Or tomorrow it can be taken up, my lord.
May I request, my lord, for the registry to be directed for the copies of the report to be furnished to both the councils.
The copy of the report dated 24/4/2025. The registry shall give a copy of the same to both the councils. List this matter on Monday.
Great.
Much obliged, my lord.
Yes, next.
Cell number 3.
Here for the petitioner. The last occasion I was directed to file a copy of the order sheet in the trial court, my lord. I may be permitted to file it along with a memo. I have filed applications to bring the legal representatives of the deceased respondents on record. I just need some time to get the correct addresses of a few respondents. But there are too many respondents in the trial
Is
court.
this matter after vacation? Yes, next.
Much obliged.
Cell
Next
number 4. Manjula.
No representation after vacation.
Cell number 5.
No dismissal. No dismissal.
Manjula. Jamuna Bai.
Petitioner, my lord, notice was served on me. I am the lower court advocate, but the party wishes to take the file back from me. That's what he informed me. So I have written. He has not taken. So I have written the letter also.
What is that?
I am the lower court
Appearing for the respondent before the trial court.
Lower court, trial court.
And you have received the notice. You informed it to your client.
No, because much prior to that, he told me that when he wants to take back the file from my side.
You are no more appearing for them.
See, it is still has not come and I have not given the NOC. But I have written a RPAD letter to him to reply and take the file back. Still, he has not taken them.
What the court wants to know is whether he is aware of the petition filed before this court or not.
Pardon? I didn't get.
Whether have you informed the client about the?
No, I have not informed the client. I have not informed because he told that when he would like to take back the file from me in the month of March.
So as of now, you are the advocate who is holding the wakalat.
Wakalat is in my name. And 16th, I have written a letter to him to take back the file from my side. This is the one. But still, he has not come forward.
What is this memo for withdrawal of petition?
That is the
Cell number 5. 5.
This is 3. 5. Avoid service of notice. The registry is directed to issue notice
To notice
to
the
respondent.
Cell number
Intermodal
six.
granted is extended in the next date of hearing. Look at it if it is there or not. Yes, next.
Cell number 6.
For petition.
Naveen Kumar.
Copy served to the. Copy served to the.
Copy?
Copy served to the city.
When is the order? When is the order for the hand summons?
I have served. The court is on Ram Durga, Your Honor. Ram Durga I have served, Your Honor. Even the
It is
speed
submitted
post,
that as per the order passed by this court.
speed post and
The notice is served on the
even
respondent.
to the petition also I served the speed post.
Notice
As
is
respondent also I
served.
served the speed post through speed post.
Who is appearing for the respondent? Who is the counsel?
In Ram Durga, Your Honor, Gulbarga, Belgaum is appearing there. Through our petitioner counsel in the Ram Durga have submitted, I have reported to them. You know. I have taken signature of that person also. On the last date, on the last page also, photocopy. That the copy has to be sent, have to come to courier.
There is a format to file the memo. Who is the advocate on whom you have served? There should be some clarity on that. Otherwise, how the court will record?
I have served the copy through RPD through respondent. Your Honor.
What is that the court has asked you to do?
But
And summons.
even Belgaum, Your Honor, Belgaum, Your Honor.
Please, notice to the respondent. Intermodal granted is extended.
Please, Your Honor, I am taking steps. Sir.
Issue notice. M. Harashchandra.
It is submitted that as per the orders passed by this court, notice is taken. For in the name of Parameshwar, SS Parameshwar, Mrs. matter. After vacation, intermodal granted is extended. Next.
Number 8.
Please, my lords.
Yes, 8.
Respondent, my lords.
Purandara.
My lords, yesterday I have filed my wakalat.
To file your
for the
wakalat.
Yes, my lords.
Uh,
In this case, I
Mrs.
have a
matter after
submission, my
vacation,
lords. I
at
have
the
a
request of
submission.
learned counsel for the respondent. Intermodal granted is extended.
My
till
lords, the
next date of
respondent
hearing.
has no objection for the case to be transferred.
Transferred?
Yes, my lords.
This transfer petition is filed seeking transfer of MC number 141 of 2024 before the senior civil judge and JMSC Chennai Patna to the jurisdictional, the family court at Bangalore. It is submitted that when the matter came up today, then counsel appearing for the respondent submits that the respondent has no objection to transfer the case from to transfer the case from so and so to so and so. Accordingly, the petition is allowed and withdrawing so and so to so and so. Yes. Next.
Till number 9.
For petitioner, my lords,
Number
postal
9.
shara is left as address is left, my lords. My lords, actually here, my lords, we have memo. I have already filed, my lords,
What
on
is the name
15/4.
of the advocate?
We have served, my lords, and my lords, acknowledgement is also returned, my lords. It is served on 19/4.
What acknowledgement?
We have served the copy to trial court advocate who represents the respondent, my lords, and they have received.
What was ordered? Hand summons.
Hand summons, my lords.
Everybody is doing what they want to do. What is the order? Nobody is bothered about it.
Even my lords.
No, notice, if you want that, take again notice.
Please,
The registry is
my lords.
directed to issue notice to the respondent.
This my interim order may be extended, my lords.
Interim order earlier granted is extended. When the court passes an order, what is this business of taking RPAD and all? Yes, 10.
Sorry, my lords.
Till number 10. Abhishek.
My lords, I appear for the petitioner. My lords, I had been to the place to issue hand summons, my lords. They have not taken it. They said they will not accept the hand summons. In fact, I have served the hand summons
Directed to
to.
issue notice to the respondents. Look at it if interim order is there extended. Next.
Till number 11.
Paper petitioner, my lord. I have served the hand summons on the respondent, my lord.
What is?
On the respondent. In the
Did
present,
who asked you to serve hand summons on the respondent? It was on the council.
counsel for the respondent. In the presence of counsel for the respondent, I have served the
Have you filed a memo to that effect saying that?
Please, please.
Look at, let's see. And asked that Jamila. A memo is filed stating that as per the order passed by this court, they serve the hand summons to the Why did you do it? That I'm not able to understand. Hand summons to the council. You
But he
say
has
that
not,
instead of that I've done this, why?
he has not put his signature on the hand summons, my lord. That's why I am
You should
serving
have
on the
informed it to
respondent.
court. You just can't do things like this. When there is an order, you have to comply with that.
Please.
Notice to the respondents, registry is directed to issue notice to the respondent. The
Please.
council shall pay the process. Yes.
Till 12.
My lord, you remark continue.
Trial court advocate
Till
has not
number 12.
received the trial court advocate not received the hand summons, my lord. In that regard, I filed the affidavit, my lord.
Notice.
Till number
Interim order, my lord.
Interim order earlier granted is extended.
Till number 13. Sripad B. Sastry.
My lord, it can be disposed of, my lord. Actually, even though I am entitled for some more amount, but if the insurance company agreed
Is the
for
respondent insurance company? Which
my lord, may
which is the respondent?
Sriram.
Sriram. How much? What is the amount you want?
my lord, not it is not mainly on liability. It is out of permitted area. Accident occurred. That is why violation of a permit condition, insurance company not at all liable to pay the compensation is the judgment of the trial court.
To pay and
My lord,
recover.
pay and recovery, yes, my lord.
That's what you want.
My lord, actually, I am entitled another 73,000. My lord, since it's a old matter, my lord, just to save the time of the court, I am ready to forego. And matter may be disposed of, directing the insurance company to pay the compensation, thereafter recover from.
Where is the finding on that?
My lord, it is found in
Last.
my lord, page number 13 after table. Permit violation.
Where do you get that para number?
Para 30.
Para 13,
Page number 13, para number 20.
20.
Page 15, my lord. Last top of 4 lines.
The claimant is before this court questioning the order passed by the tribunal, whereby the tribunal has done that the insurance company is not liable to pay the compensation. As on the day, there was no permission, there was no permit to buy the said vehicle at the place the accident has occurred. When counsel appearing for the claimant and held that the owner is liable to pay the compensation granted in amount of rupees 2,14,680. The land counsel appearing for the respondent submits that in the light of the law laid down by the apex court in Amritpal Singh's case and in Rani versus so and so, the insurance company is still liable to pay the compensation. The counsel appearing for the respondent submits that as there was no valid permit to the vehicle, the insurance company is not liable to pay the compensation. In the right of the law laid down by the apex court in so and so, so and so. Though there is no permit, still the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. Accordingly, the appeal of the claimant is partly allowed and the principle of pay and recoverable applies. Yes, next.
Cell number 14.
What about this?
AM Venkatesh for appellant.
Bring for the appellant, my lord. Service of notice to
Mr.
this
Kerala.
is awaited, my lord.
To the LRs.
Cell number 15.
Yes.
Cell number 15.
After
Ho
vacation.
Mahesh.
After vacation, next 16.
Memo.
I am appearing for the respondent, my
16.
lord.
What about this?
Venkatesh appellant. Appellant name.
This is a case for enhancement, my lordship, by the claimant. Admitted liability.
Where this national insurance company people, they are not coming forward for this Lok Adalat, Mr. Venkatesh?
I'll find out, my lord.
No, there was, we called them for the meeting. Why are they not coming up? No, see that Sriram General Insurance, they are coming and it is more than 100 cases are settled.
I'll
If they
find out.
come and instead of passing the orders, if you come forward, then we can settle at some amount. What we will do is, we will, his name is printed, Siddesh. Notice of the analysis on the counsel for the record is no more. To send notice to the direction either to pursue the matter in person or through appointed counsel. Let us see. What is the amount granted? Eight lakh
8,75,046, my lord.
How many are the entries?
My lord, please come to page 25, my lord. Loss of future income due to disability.
Left kidney with and hematoma, peritoneal free fluid suggestive of so and so, fracture of left ear blade, hyperdense collection in the bladder, left parietal. Look at page 21. The injury sustained by him.
Serious nature of injuries, my lord. I am not
There are
disputing.
2 MBCs. Which MBC is this?
This is pertaining to 8178 of 16, my lord.
8178.
Yes, on the other MVC, MFA 2184 of 18, it appears that it has been dismissed for non-prosecution.
No, 8178.
Yes, my lord.
He had sustained grievous injuries.
True, my lord.
So, under the head of pain and suffering, we will grant 1 lakh.
I have noted, my lordship.
Then, how many days he was in hospital?
Inpatient for
we'll see. Went to hospital from 8/10/2015 to 5/11. He took treatment as inpatient for 28 days. How much was granted by the court? Attendance charges, another 5,000 will grant.
Please,
Then medical expenses as it is.
as per bills, my lord.
4,11,526. Loss of income during later period. Which year is this?
Extent 2016. 2016, my lord.
2016 is 9,500. So 9,500 for these injuries for 5 months.
47,500.
Into 5. 47,500.
500.
Yes. Then what about loss of future income? What is the evidence of the doctor? Come to that discussion.
Please come to page 25, my lord. Loss of future income due to disability. PW sustained injury stated supra. He was treated conservatively, my lord. PW stated that due to extra injuries, he is getting a frequent headache and vomiting sensation. He is not able to bend his head. He became partial deaf and his left ear drum is not working. He is facing speech disability. He lost strength right hand. He is not able to do any work using right hand. In the class of PW, it is suggested today he is working and earning as he used to earlier. The extent he has stated false difficulties, denied the same. Dr. C.V. Kumar of PW3 stated he examined PW2 on 37/17 to assess disability. On exam, he found a tenderness present over left temporal region, abdomen and pelvis compression, positive, and left SRL painful. He stated the X-ray shows that malunited left iliac bone. In cross-examination, he stated that he has not treated the PW2. He has examined him clinically. PW suffered a pelvic bone fracture, head injury and abdomen injury. Ilium is a part of pelvis. Fracture is malunited. He denies that there is no basis to assess under 10% to pelvic bone. He further stated that all guidelines indicate 10% permanent disability to whole body in respect of malunited fractures of pelvis with persistent symptoms. He denies that disability assessed is on a higher side. He denies PW2 is not suffering from any disability. He stated disability is a permanent and no further treatment reduces it. He can do his job with difficulties.
So the disability is taken at 21%. 15 plus.
That's the next page, my lord.
21% is a disability. So with this income, 9,500 into 12 into 18 into 21. It comes to 4,30,920. Then towards loss of amenities.
Amenities 20,000 is granted, my lord.
Another 20.
Future medical 20,000 is granted.
Loss of amenities 40,000. Future medical expenses another 10,000. Legal expenses another 10,000. It comes to 10,79,946 against granted compensation of 8,75,046. Please come. agreed with the award passed in MSc number 8175 of 2016, dated 13th December 2017. The claimant is before this court. The claim petition is filed seeking compensation of an amount of rupees. How much was sought? An amount of rupees 30 lakhs for the injuries sustained by the claimant. As per the wound certificate and other medical records, the claimant had sustained the following injuries. At page 20, at paragraph number 17, the injuries are there, extract. According to the doctor, he had sustained disability at 10% and 35%, and court had taken it at 8% and 25%, and to the whole body it was taken at 21% and granted the compensation as per the table given below, above 18, paragraph 18. As advocate for the appellant is no more, notice was ordered to the appellant, and no wakalat is filed on his behalf. Not there is an apparent, not he has appeared before this court. Heard the learned counsel for the respondent, considering the fact that this is an MBC of 2018. This court is passing the order on the merits of it. Considering the grievous injuries that are sustained by the claimant under the head of pain and suffering, this court is granting an amount of rupees 1 lakh. He was there in the hospital for 27 days. Under the head of attendant and nourishment charges, this court is granting 30,000. There is no interference called for in the medical expenses. Then coming to the loss of income during the later period, this accident has happened in the year 2016, and this court is taking 9,500 into for the 5 months, 47,500. Coming to the loss of future income, court had rightly taken the disability at 21%. So the income at 9,500 into 12 into 18 into 21 by 100 is 4,36,920. And to his loss of amenities, 40,000. Future medical expenses. Future medical expenses, 30,000. This court is granting 30,000. And in the light of the law laid down in make laws so and so, 10,000 towards legal expenses. Altogether, the claimant is entitled for an amount of rupees 10,99,946. Accordingly, the appeal is partly allowed, enhancing the compensation from 8,75,0462 to 10,99,946. Yes, next.
So number 17.
I am the appellant, my lord. Two more matters to be connected along with this, my lord.
Post along with so and so after vacation. Next. 18.
Cell number 18. Cell number 18.
Yes.
Prakash Ramich.
No representation after vacation.
Cell number 19.
My lord, I am filing the memo. Kindly dispense with the notice issuance to the respondent number 1, my lord.
Respondent number
1.
A memo is
Exporter
filed
has
seeking
been-
dispensation of notice to R1. Dispense with at the risk of appellant. It is a list of counsels.
Reliance General Insurance.
Huh?
Reliance General Insurance, respondent number 2 is there.
Who appears for Reliance General Insurance? Pradeep, you appear? Mr. Pradeep takes notice on behalf of the Reliance General Insurance in the name of Mr. So and so, and the council shall serve the copy of the, it's for enhancement.
Yes, my lord. Claimant civil for
Pradeep,
enhancement, my lord. Case of the injury, my lord.
They are coming for the Lok Adalat.
Tomorrow, I don't know
Reliance General
whether it
Insurance.
has been listed or I don't know my lord, whether it has been listed Reliance company.
Or shall I post it for tomorrow for the Lok Adalat?
Please, my lord. Maybe
Please, my lord.
Tomorrow, list is matter for the Lok Adalat tomorrow. Case 20.
Cell number 20.
For appellant.
Nagaraj Reddy.
The matter may be connected with one more MF, my lordship, 7 to 4.
So and so along with it after vacation. Next,
1 week time
huh?
to take steps, my lordship.
After vacation, yes, next.
Serial number, hearing on interlocutor application 20, serial number 21. Case Chandrahasa.
I am for the respondent, your lordship.
This is filed, the petition is filed under rent act, my lord, under
This has to
section.
be heard finally. Because there is no question of no permission to deposit under
Your
the.
lordship, the rent may be asked to be
No,
deposit in the court.
My learner friend has taken the rent in the open, last date of hearing.
That is
His
for 1
client,
month.
I have given personally on hand, I have given, he said that I will not.
1 month we have taken for the rent. The remaining rent may be deposit in the court.
I will pay it directly to him, but it's a small amount,
2000 is per month.
150 rupees.
2000 is per month.
No, not.
Your
Even
Honor,
in the
in
petition,
the lower
in the
court,
order
in the
also it is
objection,
150.
statement objection, they have
150, even,
admitted.
their petition is also 150.
No, no.
The petition, it is
This
specifically
is matter
mentioned.
after vacation. We'll see next matter.
Serial number
The
22.
stay may be continued, madam.
Interim order granted is extended till then. Yes, 22.
Serial number 22.
I number 1 of 17 is filed to condone the delay on condition after vacation.
Filed objections delay condoning 8 and 67 days, my lord.
On condition, we are condoning thousands of days. What is the difficulty for you? Yes.
3 appeals are.
This is owner appeal, my lord.
20 which one?
The appeal is by the owner.
Owner.
Please.
No problem. No condition, condone. Yes,
Please.
next. 22.1.
Serial number 22.
No, in case the owner's appeal is allowed, the owner is liable to pay the interest for the period of delay.
Please.
Next, even 22.2 also, it is by the claimant.
22.2 is by the.
22.2.
22.2, 22.3.
No, 22 is by Mr. Shantaraj. And 22.2 by Mr. Gurudev Prasad. That is by the claimant.
Owner's appeal. 22.2, 3 and 4.
So all these matters, the same, condone if it is allowed, the owner has to pay the interest for the said period.
Please.
Next,
Serial number 23.
23.
23, I am ready. Case of injury for enhancement of
Hearing
compensation.
for the respondent, maybe dispose of.
Huh.
Claim amount is 10 lakh.
Hmm.
The compensation awarded 5 lakh 8,000.
Hmm.
Here in
That's okay.
para
Income-
13 of the judgment, she suffered a open compound bimalar,
How many are the injuries?
2 fractures, 1
Fracture.
dislocation.
3 fractures?
2 fractures.
2 fractures, 1 dislocation.
Hmm.
And she undergone 2 major operation. One is for
75,000 already granted. Pain and
for
suffering.
pain and suffering. I have no grievance so far as pain and suffering.
So next, medical expenses?
Medical expenses as it is 1,86,000.
1
and,
lakh.
Incidental
261.
also
How many days in hospital?
5 days, 2 occasions she
So
was,
10,000 reasonable.
yes.
Then, no, what?
10,000 again
Is
10,000.
more than it is given, 10 plus 10, 20 is given. Then loss of amenities, what is the disability?
Disability,
10%.
doctor says 30% to the whole body, 15%. And
So it can be
she,
another 20%, 20,000 for loss of amenities.
she is a tailor by profession. Because of these fractures and disability, she cannot operate the
So
machine.
30,000.
Yes,
Next,
yes.
loss of future income.
That has to be recalculated.
We'll calculate.
Court has taken 9,000 rupees income,
It should be
12,500.
12,500 into 12 into 14, 10%, 2 lakh 10,000.
12 into 14 into 10.
2 lakh 10,000.
2 lakh?
10,000.
Hmm. Hmm.
And
What is this automatic sewing machine cost?
because
Tailoring
she
machine,
cannot
automatic,
operate.
Oh, even your submission is already answered here.
Yes, yes. And future medical
50,000.
expense.
Future medical expenses, 50,000.
Oh, and loss of income during later period has not.
Is not granted.
Yes.
Hmm. So loss of income during later period. So
37,000.
12,500
37,500.
into 4.
3 million.
Hmm?
Only 5 days inpatient.
Into 3. It comes to 37,500. It's coming to 6,23,761.
Yes.
Which is the insurance company?
This is Bharti AXA, my lord. No, it is merged with ICICI. My lordship may pass a judicial order.
No, can it be for the Lok Adalat?
No, my lord, my lordship may pass a judicial order. No, it's
Agreed with orders passed in MSC number 4703 of 2018, dated 28th February 2019. The claimant is there before this court seeking enhancement of the compensation. The amount claimed is 10 lakhs and the tribunal has awarded an amount of rupees 5,07,461. Then council submits that the income is taken at
9,000.
which is on the lower side. Further, no income, no amount is awarded and the head of loss of income during the later period, and for the amenities and other heads, the amount that is granted by the tribunal is on the lower side. Land council appearing for the insurance company submits that the court had granted a just and reasonable compensation. Next para. This court has perused the order passed by the tribunal and the head of pain and suffering and medical expenses and the conveyance transport, the court had granted a reasonable amount. No interference is called for. Considering the disability of 10%, this court is granting an amount of 30,000 towards the loss of amenities. Coming to the loss of future income. This accident had taken place in the year
2018.
2018, and the income is taken at 12,500 into 12 into 14 into 10 by 100 is 2,10,000. Then the court had rightly granted for the machine an amount of rupees automatic machine for an amount of 15,000, and for future medical expenses 50,000, and no interference is called for. Coming to the loss of income during the later period for for 12,500 for 3 months, it comes to 37,500. Legal expenses in the light of so and so, 10,000. Altogether, the claimant is entitled for 6,33,761. Accordingly, the appeal is partly allowed, enhancing from 5,07,461 to 6,33,761. Enhanced amount shall carry 6% interest. Next.
Still number 24. Press Dabali.
Release the amount. They have challenged the contributory negligence and quantum.
Your murder. The entire amount has been deposited along with interest. Let them withdraw about 30% of the amount which has been deposited before the tribunal.
You question the contributory negligence.
Negligence as well as the quantum also.
How much is how much is apportioned?
No, there is no apportionment murder.
Contribute. Oh, you say that he is contributed to the accident. We'll say 50% to be withdrawn. IN number 1025 is filed seeking withdrawal of the amount. The claimant is permitted to withdraw half of the 50% you have deposited.
No, entire amount too.
50% of the amount the claimant is entitled to withdraw, which is subject to the result of the writ petition.
And balance amount can be kept in the FD mode. Balance amount can be kept in the FD mode because
the balance amount shall be kept in the FD. Is next 25.
There is delay murder.
Number 122 is filed to condone the delay of 20
Posted along
days.
with another memo.
Condoned, admit, post for final hearing along with
45.
write on a paper and give yes. Next.
Still number 25.
Number 22, my lord. First two matters were totally different from other three matters. Wrongly it were connected.
Which has to be dealing?
22, first two matters belongs to one.
Dealing 22 and 22.1 from the remaining matters.
Remaining matters.
Yes, next.
Still number 25.
25 days.
Nagaraj Reddy.
Delay minutes. Copy has been served to the advocate.
All are served. I1 of 22 is filed to condone the delay of 25 days. For the reasons condoned, admit, post for final hearing, PCR.
Still number 26.
Lord, I pray for accommodation, my lord. I pray for accommodation, my lord, in this.
After vacation.
Please.
Yes, next.
Still number 27.
At the request of our counsel for the appellant. Is 27?
27. P and Naresh.
Yes.
Transfer of the appeal, regular appeal, pending before the district judge to the Istanbul court, because Lord, the suit for partition is filed. I am the plaintiff.
No, what are you seeking? You're seeking transfer of?
Transfer of the appeal filed before the district judge by the defendant to the Istanbul court, because the Istanbul court I have filed an appeal. Because what has happened is all, I am the plaintiff. suit is filed for partition. There are about there are schedule A to G. Suit is decreed for A schedule and B schedule. So for the C schedule to G schedule, the suit is dismissed.
We'll take out notice.
That there is an appeal pending that is going on. That's because there will be chance of divergent finding.
No, now the issue is.
Please.
Coming holidays, we'll list it immediately after vacation. The
Because there are so
petitioner
many
shall
respondents.
take out notice to the respondent, hand summons on the council. to
And
the
summons, but
respondent.
because there are so many
And
respondents.
then the
Notice.
registry is directed to issue notice to the respondents. This is matter on 12th of June.
Please.
Yes, next.
Cell number 28.
Yes.
Please adjourn the matter, my lord. My senior is out of session.
The petitioner in this case.
Interim order is there.
Yeah, interim order is there.
At the request of land council, the respondent.
No, my lord, matter is pending for more than,
My lord, senior is out of.
CP of 2025.
yes,
There are
ma'am.
so many matters pending from much before this. At the request of land council, the respondents, list this matter after vacation.
No, date may be.
And the interim order earlier granted is extended till that. Give some date. Yes, next.
Cell number
Date may be
29,
mentioned.
Still we fixed. There are so many matters, all. we have to
I
look
I
at
attend
it.
for the respondent. Kindly, I am permitted to file objection. Last week I
I
filed.
have for the wife, my lordship. Kindly, stay may be extended.
Same order in 29 also. Then 30.
Cell number 30.
Yes, 30.
Number 30. Venugopal.
Should give that. The petition is filed seeking transfer of suit. List this matter after vacation, no representation for the petitioner. Yes, 31.
Number 31. Leeladhar HP.
Is it
After
landlord,
vacation.
landlord?
No IA,
Huh? Pardon?
no interlocutory application is there. A post of final hearing, admit post of final hearing.
Meanwhile,
Yes, 32.
Cell number 32.
records call madam.
Call for the DCR. Yes, next.
Cell
I
number
appear for the
32,
caveat, my lord. Lord, yesterday evening I received the copy, my lord. This matter Monday, my lord. I have to take instructions from the matter.
ಅವತ್ತು ಇನ್ನೊಂದು 19th ಕೋರ್ಟ್ ಹಾಲಲ್ಲಿ ಒಂದಿದೆ ಮೈ ಲಾಸ್ಟ್ 19th ಕೋರ್ಟ್ ಹಾಲಲ್ಲಿ ಇದೆ ಒಂದಿಷ್ಟು ಅದರಿಂದ ಇವತ್ತು
Is, saying
ಕೈಂಡ್ಲಿ ಇಯರ್ ಸ್ವಲ್ಪ ಇಯರ್ ಮಾಡಿ ಇಸ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ದಟ್ ಇಸ್ 27th ಗೆ 4 months ಟೈಮ್ ಏನ್ ಕೊಟ್ಟಿದಾರೋ ಅದು ಎಂಡ್ ಆಗತ್ತೆ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ದಟ್ ಇಸ್ ಅವಾಗ ವೆಕೇಶನ್ ಇರುತ್ತೆ ಮೈ
English.
ಅದರಿಂದ ಸೊ ಕೈಂಡ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ದಟ್ ಇಸ್ ಟೇಕ್ till next date of hearing ಕೊಡಿ my lordship. That is my IA1 prayer, my lord.
This is
Kindly peruse the prayer, my lord. That
Let's
is-
just stay in this.
No, my lord. Fresh matter, my lord.
Next date of hearing ವರ್ಗೂ ಕೊಡಿ my.
Fresh matter.
This matter on Monday, no, but Monday. Yes, 33,
My
no
lordship.
stay.
Number 33.
Without hearing, no stay. 33.
33. Shiva
Yes.
Reddy.
No representation after vacation.
Cell number 34. Sitaram Rao BC.
That's liability appeal minutes, short point, no policy, no liability minutes. There was no policy at all.
I'm the owner of the vehicle, my lord.
All the more reason.
No policy at all minutes, there cannot be any liability.
After vacation.
After vacation. Yes, next.
Cell number 35.
At the request of one council
Number
respondent.
35.1, I have filed an IA for permission to deposit my share towards before this honorable court. It's an ECA appeal, my lord. I may be permitted to deposit 1,60,000.
IA number
For this humble
1 of 24 is ordered permitting the applicant to deposit the amount. This is matter after vacation.
Amount before this honorable court.
Yes,
Cell
next.
number 36.
Please.
What about
Ganesha.
36?
Ganesha.
No representation after vacation.
Cell number 37. Ravi Shankar Shastri ji.
The respondent, my lord.
LDC, no representation after vacation is 38.
Cell number 38.
Get Mr. Shivanagoda.
Syed Abdul.
Phantom.
Sriram.
Yes. Give the file.
Yes, sustained cervical spine problem.
How many-
Doctor has assessed 90% disability.
90%.
It is taken also.
It is taken also.
It is taken.
What is the age?
31 years.
31 years.
Para 22,
Pain and suffering is 20,000.
40,000.
Wrong file or what?
1246 of 21 MSc.
3517, 1246. Where do you get the table?
Table is in para 23, my lord.
Correct 23. No, I think something is wrong with your this thing. Here, the amount that is awarded is 98,400.
No, my lord. MSc 1246 of 12.
MFA 3517 of 2021.
3517, correct.
MBC 1246 of 2012.
Correct.
Where do you get the amount?
Para 23. Pain and suffering,
Yes, yes, yes.
40,000.
Yes, yes. So, pain, what is the 80% disability?
90%.
90% disability and pain and suffering of 40,000. It has to be 1 lakh.
Lord, way back 2012.
Whenever
That is
it
the
is
reason.
90% disability is
No,
something.
at that point of time, this is the pain and suffering was very less. That's the reason it is.
We are not considering
Please,
all that.
please.
We are giving normally and all the matters.
Medical expenses as it is.
As it is. How many days he was in hospital?
He was in hospitalization for 7 to at least 2 months. 60 days in the hospital.
From 28/10/2011 to 27/12.
60 days.
60 days. So, food, diet, conveyance, so and so, 60,000. Then loss of income during later period.
2012 accident. 4,000 is taken.
How much to be taken?
4,000 is taken. 2012.
7,000.
No, 2011. Sorry. 2011 date of accident.
2011.
6,000.
6,500. 6,500 into 6
40%.
months.
Ah.
It comes to 39,000. Then
Loss of future income.
future income. Now 6,500
40%.
plus 40%. It comes to 2,600.
16 multiplier.
9,100 into 12 into 16. Into disability is 90.
90%.
It's coming to 15 lakhs 72,480.
Okay.
Then loss of amenities. What do you say?
Another 50,000 maybe granted.
Another 50. That is total 60.
Correct.
So all are covered.
It is covered. My lord. Loss of
Amenities is 60,000. Loss of income during the later period is also granted.
future medical expenses.
Future
required to be
medical
granted. It is not granted, but it is required to be granted.
50,000.
Your lordship can.
So plus
20 ಲಕ್ಷ. ಮಾಡ್ತಾರೆ.
it comes to 19 lakhs 71,487. Huh? Judicial order. Please no. Agreed with the orders passed in. Where is the council?
They have not appeared.
Syed Abdul Pasha, Akbar Pasha,
Heard the land counts for the respondent insurance company, no representation for the appellant. This is matter as part heard on Monday.
Next.
Bill number 39, Vijay Kumar D. Vijay Kumar.
After vacation. Yes,
Bill
please.
number 40. Bill number 40,
Yes, where is Renuka?
K. Shantaraj, HR Renuka.
Authorized is not well, my lord.
After vacation, 41.
Bill number 41.
My lord. My lord, my prayer, this is entire records is in Tamil, my lord. This has to be translated and placed before the court, my lord.
Why?
This is, my lord, this is case under 163A. The tortfeasor himself is charge sheeted. He is not liable to pay compensation on 163A. I had to go through the entire records and make a submission to the court by translating them.
All these records, traveling, translating, and I think it will take another 15 years.
No,
It's
my lord.
already 2013.
2 weeks to get
No, 13 years are
I'll
over.
file it within 2 weeks, my lord. After vacation, may.
After vacation.
Please.
Next 42.
Bill number 42.
Where is Renuka?
Venkataraman Naik, HR Renuka for R2.
My lord, it's an injury case.
There are so many matters. Passover.
42 Passover. 43.
43.
43.
I request my lordship may kindly pause over my lordship may.
Which one?
43.
43, my lord.
Ramesh Kumar
I
Azad.
Please here we can take up 42. She has come, please. It's 42 call 42.
42.
You're ready with that? Afternoon. Yes.
I have this number 4, quite a.
Small matter it is,
Yes,
madam.
yes.
81 years old injury case. I given the copies. Nothing.
Short Passover. Short. Yes, yes. Next 43 Passover. 44.
44. Ravi Shankar Shastri.
Appellant, my lord.
A.M. Venkatesh.
Yes, sorry, my lord, I was not. My lord, case of death, my lord.
There should be some enhancement, my lord.
You are very
Notional
fortunate.
income taken is on a lower side, my lord.
You are very fortunate that he said that there should be some.
My lord, he will start now, my lord, on the another point.
Give that.
My lord, my case is that, my lord, there is 1/3 should have been deducted. Wife and daughter are the claimants. Then, my lord, date of accident.
1/3, then how much should be deducted?
My lord, they have 50% was deducted, my lord, by the MACT.
So.
9/7/2015 is the date of accident.
9/7.
2015.
What
Wife
is
and
the age?
age of the deceased was 58 years, my lord.
58 years.
Claimed income was 25,000 to 30,000. Since
What is that?
the PW2, my lord, was employer was examined, showing that, my lord, he was doing a catering business and he was working under him. But, my lord,
So how much should be taken?
leave to the court, my lord.
No, no, like as per the chart?
As per
It
chart
was
only.
9,000.
9,000.
Yes, my lord.
So 9,000, there are no future prospects or 10%?
10%, my lord.
That is 900.
Please.
9,900. 1/3. It comes to 3,300. Contribution is 6,600 into 12. Multiplier?
Not 5. 11.
You said age is?
My lord, age is 58 years, my lord. It is 11, my lord. 11.
No, it appears to be 9.
9, my. 11. 50.
11 was taken by the MACT, my lord.
But if that is the age, it is 9.
Yes.
It's coming to 7,12,800. So then towards consortium, 88,000, 36,000.
And 15 days, my lord, I was the inpatient. Therefore,
Medical bills are there.
medical bills was there, my lord.
How much?
5,40,000, my lord. 5,40,000.
5,40,000 was the medical bill.
Medical bills, 5 lakh.
40,000. And since he was inpatient for a period of 15 days, my lord, he was in coma stage for 22 days. 15,000 was incidental, was awarded by MACT.
So it's coming to 13 lakhs, 91,800. How much was awarded?
13,08,000 was awarded.
So that's why he said small enhancement. 13,08,000 is awarded. Yes, please come.
No, the age was taken as 55 years, my lord, and 11 was multiplied. I'm
50
sorry.
years. Then we have to do the calculation on
I'm
that.
sorry, my lord. I made a wrong note in my notes.
66,000. 6,600 into 12 into 11.
Please.
Age is 55.
55 years.
Then it's coming to 8,71,200 plus 36,000. It's coming to 15 lakhs. 15 lakhs, 50,200.
Please.
Agreed with award passed in MVC number 1704 of 2014, dated 25th January 2017. The claimant is before this court seeking enhancement of the compensation. The claimants have filed the claim petition seeking compensation of an amount of rupees 50 lakhs for the death of the deceased. It is a case of the claimant that is earning 25,000 per month.
Please.
By doing catering business. And the tribunal had taken the income at?
8,000 was taken.
Had taken the income at 8,000. When it comes to 8,000 and
Age noted by the learned.
Huh?
Age noted by the learned, you see at paragraph 23 is 56 years, my lord.
How much?
56 years. Para 23.
Same multiplier, even 56.
It is same multiplier. More than that, the second respondent is a married daughter living with her parents, my lord. That's why the MACT has rightly taken 50%.
No, unmarried.
Unmarried is a different issue, my lord.
3 dependents, 1 to 3 dependents. Or what has to be deducted?
1/3.
1/3. No, let us assume that daughter is not the dependent. Still,
No.
it has to be 1/3. He will not become a bachelor because it's only one.
Yes.
What did you do? By doing catering business, tribunal has taken income as 8,000.
8,000 per month.
8,000 and deducted 50% and granted compensation of an amount of rupees 13,000, 13 lakhs 8,000. In that, an amount of rupees 5,40,000 is granted towards medicines and 15,000 for the hospitalization towards the attendant charges. The counsel appearing for the claimant submits that when it is a case of the claimant that is earning 25,000, the deceased is earning 25,000, court ought to have not taken 8,000. Further, it is submitted that the court ought to have deducted 1/3 instead of ought to have deducted 1/3, but the court had deducted 50%, and the compensation that is awarded is not reasonable. Next paragraph. When counsel appearing with respondent insurance company submits that the court had rightly granted compensation, but there are no grounds to interfere. Next paragraph. This accident had taken place in the year
2015, my lord.
2015, and this court is taking 9,000 as the income, and towards the future prospects, 10%, 900. It comes to 9,900, and the deduction towards personal expenses, the wife is the wife and the daughter of the dependent, this court is deducting 1/3. It comes to 3,300, and his contribution to the family is 6,600 into 12 into 11 is 8,71,200. Towards consortium for 2 people, 88,000 for the wife and the daughter, and funeral expenses 36,000. The court had granted the medical and transport to attendant benefits 5,40,000 and 15,000, and this court finds no reasons to interfere. Next, in the light of the law laid down in Mekla versus so and so, towards legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 15,60,200. Accordingly, the bill is partly allowed, enhancing the compensation from 13,08,000 to 15,50,200.
Interest granted is 9.
200.
Interest
Then the
granted is
enhanced promotion
9%,
carries
my lord.
6%.
Bill number 45.
Yes, next.
45. K. Suryanarayan Rao, appellant.
After vacation,
Bill number 46. Guru Prasad BR,
who appears with the respondents?
Punacha.
respondent, that is MU Punacha.
Punacha.
Password?
Yes.
Password.
Yes.
Yes, we'll see remaining after.
These three, my lord.
List 3 will not be adjourned, especially listed. Because all these matters are pending before the trial courts as there are stays. And as it was brought to my notice, all these matters are listed. List 3 will not be adjourned.
List 3.
Maximum, it can be on Monday.
No,
further.
my lord, in the afternoon and till Tuesday, your lordship, I have informed the other side also, my lord.
Which matter?
List 3, serial number 5. My learned friend is also here. Tuesday.
List 3, serial number 5. List this matter on Tuesday in the specially mentioned matters. No adjournments will be granted further. Yes.
And interim order to continue. It's that.
Interim order earlier granted is extended.
Serial-
And,
List
why
4,
everybody
serial
is
number
making
57.
mentions? Please don't make mentions.
Serial number
Court
7,
57, my lord.
See in the afternoon.
my lord, serial number 7, my lord.
Please.
Same, my lord, same list, my lord.
List 4,
Same
my
list,
lord.
my
I
lord.
was only responding to him to say that I'll not grant adjournments. And as a matter, I don't hear the adjournments in the afternoon.
7 is, my lord, the compromise is going on, my lord, with regard to the daughter, my lord.
Let the suit cannot be kept pending. If compromise is going on, you should have done it long back. List 3 will 5 months. List 3 will 5 for
Court officer?
Sir, 1 ನಿಮಿಷ.
ಆಯ್ತು.
ಇದೆಲ್ಲ ಇವ್ರಿಗೆ ಟೇಬಲ್ ಮೇಲೆ ಇರೋದೆಲ್ಲ
ಚೆಕ್ ಮಾಡೋದಿದೆ.
ಎಲ್ಲ ತಗೋತಾರೆ ಸರ್, ಎಲ್ಲ ತಗೋತಾರೆ. ಇಲ್ಲ ಯಾವ್ದು ಅಡ್ಜರ್ಮೆಂಟೇ
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್, ಲಿಸ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಅಲ್ಲಿ
ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಲಿಸ್ಟು ಹೇಳಿ ಸರ್.
ಹಾ,
ಅದು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹೋಗಿದೆ.
ಅಪ್ಲಿಕೇಶನ್ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ.
ಫೈಲಿಂಗ್ ಆಫ್ ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಅಂತಿತ್ತು. ಅದು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹೋಯ್ತು.
ಅಲ್ಲ, ಅದೇನಾಗಿದೆ, ಕಾಮನ್ ಪಬ್ಲಿಕೇಶನ್ ಆಗಿತ್ತು, ಅದಕ್ಕೋಸ್ಕರ
ಇದು ಪಾರ್ಟ್ಲಿ.
ಆಯ್ತು.
ಮೇಡಮ್
ಹೇಳಿ ಹೇಳಿ
ಕೋರ್ಟ್ ಆಫೀಸರ್,
ಹೇಳಿ.
ಲಿಸ್ಟ್ 4 ನಲ್ಲಿ 6 ಅವರು ಟೈಮ್ ಏನಾದ್ರು ತಗೊಂಡ್ರ ಬೆಳಿಗ್ಗೆ? ಲಿಸ್ಟ್ 4 6th ಮ್ಯಾಟರ್.
ಲಿಸ್ಟ್ 4 ಎಲ್ಲ ಹಂಗೆ ಇದೆ, ಕರಿತೀನಿ. ಈಚ್ ಅಂಡ್ ಎವರಿ ಕೇಸ್ ವಿಲ್ ಬಿ ಕಾಲ್ಡ್ ಔಟ್ ಇನ್ ದ ಆಫ್ಟರ್ನೂನ್.
ಓಕೆ ಮೇಡಮ್, ಓಕೆ.
ಎಲ್ಲ ಮ್ಯಾಟ್ರು ಕಾಲ್ ಔಟ್ ಮಾಡ್ತೀನಿ. ಲಿಸ್ಟ್ 4 ಅಲ್ಲಿ ಯಾವ್ದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಮೇಡಮ್.
ಓಕೆ, ಫಸ್ಟ್ ಕರಿತೀರಾ ಮೇಡಮ್ ಅದು? ಇಲ್ಲ ಇದು ಲಿಸ್ಟ್
ಮೇಡಮ್, ನಾನು ಪದೇ ಪದೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಲಿಸ್ಟ್ ಕಾಲ್ ಔಟ್ ಮಾಡ್ತೀನಿ ಅಂತ. ಹೌ ಮೆನಿ ಟೈಮ್ಸ್ ಯು ಆರ್ ಆಸ್ಕಿಂಗ್ ವೆದರ್ ಯು ಆರ್ ಕಾಲಿಂಗ್? ಐ ವಿಲ್ ಬಿ ಡೆಫಿನೆಟ್ಲಿ ಕಾಲಿಂಗ್ ದ ಮ್ಯಾಟರ್ ಇನ್ ದ ಆಫ್ಟರ್ನೂನ್.
ಮೇಡಮ್ ಸಾರಿ, ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 13 ಅಮೌಂಟ್ ಎಷ್ಟು ಅಂತ ಒಂದ್ ಮಾತು ಹೇಳ್ತೀರಾ?
1 ನಿಮಿಷ ಸರ್.
ಆಯ್ತಮ್ಮ.
ಒಂದಲ್ಲಿ 13 ಅದು ಲೋಕ ಅದಾಲತ್ ಮುಂದೆ 26/4ಕ್ಕೆ ಅಬೋ ಅದೇನೆ 1,50,000
ಹಾ ಆಯ್ತಮ್ಮ.
ಓವರ್ ಅಂಡ್ ಅಬೌವ್.
ಓಕೆ ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಇನ್ನೂ ಇದೆ ಇದೊಂದು
Kota sir? Kota sir? Kota sir? Madam? Kota sir?
My lord, on submission. List number 2, serial number 30, my lord. I have held up in some other court. It had been adjourned to August, my lord. It's very urgency. The petition filed by wife is pending in Mysore. She is having two minor children, sir. Along with she has to attend the job in college. She is a lecturer, my lord. Very urgency is there. The petition filed by husband is pending in Tumkur.
Which one?
Serial number 30, list number 2.
Serial number 30.
Yes.
30 is the MFA. What to do when you're not there?
Some other court I have.
Somebody should be here. Your colleague should be here. Should have been here. You get the file. Yes, call the list. Call the password.
Password.
Serial number 30. In that minute, owner has not served. According to the cause list minute, the appeal stands dismissed against the owner of the vehicle. Subsequently, he filed application on 2/4/24. On that day, the earlier order, dismissal order was recalled. He has to file a memo to dispense with the notice to the owner because he placed ex parte before the court. That he has to file.
Is there.
Then how can it be? No, if notice, how the notice can be dispensed to the owner?
My lord, may I submit, my lord? My lord,
Then
as
that
per
memo is
C.
not ordered.
No, yes, not.
No, it's not.
No, according to the cause list minute, the appeal dismiss against
That is
the
a-
you can see the cause list.
That is
Serial number 30.
List 2, serial number 30.
look at take that file again.
Yes, ma'am.
It is there, right? Just now.
My lord,
That memo is there.
Memo, he has to file memo.
Now he
my oral submission may be taken on record, my lord, because matter is a very, my lord, only pay and recovery order. Even I am not argued for enhancement also.
And
My
even
lord,
your memo will be filed by the counsel for the insurance company.
He has to file memo. Dispensation.
Madam,
File.
dispensation, my lord, I will file during the course of
Write a
this
memo.
week. I may be permitted to file the dispensation memo, my lord, or my oral submission may be taken on record.
It is submitted that the notice to the owner is not, may be dispensed with, as he has placed ex parte before the trial
Tribunal.
court. And it is submitted that they will come, he'll file a memo in that regard. Now it is coming to, now it is already disposed of.
Yes, it is disposed of.
This matter on Monday, by Monday file a memo.
The interest portion is concerned. On that day, from 9/1/2018 to 4/2/4/24.
Anyhow, that day the matter will be coming up.
Please,
We will
please.
tell the court. Yes, next. Yes,
Passed over matters, list number 1, serial number 1, R. Shashidhara for appellant, B. Pradeep.
End up in court on 19 minutes. Next week.
Now, insurance company appeal, you have contested the appeal, appeal is dismissed, and let him come, we'll wait. When once he comes, we'll call again with listing the matter. Next.
Serial number 6. Vinod Kumar M. Yes, Narendra for.
Morning, ask for a passover, I think.
He is not.
You were not present, no.
Matter has been settled, my lord. Mediation report is kept below, my lord.
Hmm.
Main matter is itself disposed of.
The 80,000 he can.
Please, there is no objection from the respondent, my lord.
Memo. The
As
memo
per
is
the-
filed stating that. A memo is filed stating that as per the mediation, the marriage is dissolved. Dissolved. It is submitted that as per the said report, an amount of it is submitted that an amount of rupees 80,000 is already deposited before this court, and as per that, as per the same, as per the agreement, the petitioner can withdraw the said amount. And land counsel for the respondent submits that.
I have no
that-
objection for
That
withdrawal.
he has no objection. Accordingly, the memo is taken on record, and the same is dismissed as withdrawn, and the petitioner is at liberty to withdraw the Yes.
My lord,
Yes,
regarding the
yes.
payment of 50% deposit, it would be my humble submission that the applicant is a farmer, my lord. Really does not have.
How much is the compensation granted?
14 lakh. Exactly, it is 14 lakh 46,200.
No, we can't grant an order without condition. If we can't, let the notice to the respondents. Yes, next.
Cell number 28.
Yes.
28.
My lord, I'm sorry for the interruption. A date may be given.
After vacation on Liz's matter on 17th July. Yes.
Cell number 28.
2,40,000.
Agreed. Insurance company.
In addition to
submitted
what
insurance
has-
Company is ready to pay an amount of rupees
2,40,000.
2,40,000 in addition to what has
What
been
has been
granted at 6% in interest at
No,
6%. No interest.
And pay and recovery
And
retime.
they'll file a memo.
Pay and recovery retime.
They'll pay,
It is on.
they will file a memo before the Lok Adalat, and already pay and recovery is ordered.
Please.
Yes, next.
26.
On 26th, Lok Adalat. Yes,
Cell
next.
number 42.
42.
List number 2, serial number 42.
Letter, lump sum 1.25.
I just, but I request my lord,
No.
150 it will be.
No, my lord.
Because
Because
6%
it may be
also
posted
it is
tomorrow.
11 years
Because
appeal period.
without even asking them, my lord, I've settled, my
that's
lord. In
why
fact,
we're waiting.
Shivana Gowda has settled, my lord.
It is submitted that the respondent RTC.
No, Bajaj.
Bajaj, the respondent, it is submitted with the land counsel appearing for the insurance company that they're ready to pay an amount of
1.25 lump sum.
1.25 lump sum against or in addition to what has been
In
awarded by the
yes.
tribunal, and a memo will be filed in that regard. This is matter before the Lok Adalat on 26th. Yes, next.
Cell number 43. 43 Shiva Reddy KN. Ramesh.
Owner appeal.
Owner's
There
appeal.
was no DL. Now he's, a learner's license was there. There is no evidence that rule 3 is complied. So when an owner comes in appeal, where is the question of pay and recovery, my lord?
This will have after vacation, no time for this today. After vacation.
Two citations, my lord.
That's why, because there is no time for the hearing. All these matters are set up for a fast adjudication. Yes, after vacation.
The
Cell
date
number
may
40.
kindly be given.
Huh?
The date may kindly.
Date on 24th of June. Next.
Cell number 46.
40?
6.
Yes, where is Mr. Guru Prasad?
Cell number 46. We are Guru
Have you
Prasad.
informed him, Mr. Punacha?
You Punacha.
Which is the insurance company, United India Insurance Company. Shall I post it for the Lok Adalat? No scope.
After vacation.
This is matter after vacation. Yes, next.
Number 3. List number 3. Serial number 1. We are Balraj.
What about notice to respondent?
Not yet served.
Huh?
As per postal share, not yet served.
Post after service of notice. Yes, next.
One
Two.
submission, my lord. Petition filed by the wife. Stay is not granted. A number 1 has to be considered because.
2024
Can
and
make one submission. If
2025.
stay is granted, definitely they can appear.
We will not grant for 2024 matter now. Two. Huh? There is no stay in this. Why is this registered? Show it. No. If stay is not there, it wouldn't have come. There is a stay in this. When counsel the petitioner permitted to take out notice on the respondent counsel, there shall be an interim stay as sought for till the next date of hearing, come here. As per the postal shara, neither cover nor acknowledgement received as per so and so amount to deemed service of notice. Okay. Neither the cover nor the acknowledgement received as per what? What is the project? It amounts to deemed service of notice. Argue.
The petition filed by the, after filing of the petition filed by the wife. For maintenance number 458 for.
Transferring the MC petition from
Hassan
to the
Hassan to Mysore.
distance.
120 kilometers.
The present petition is filed seeking transfer of MC number 189 of 2024 from the Principal Judge Family Court, Hassan, to the court of the Principal Judge Family Court at Mysore, and to Family Court at Mysore. It is submitted that the distance between both the places is about 120 kilometers, and
First petition filed by the wife.
And already the wife had filed a maintenance petition before the Family Court at Mysore, that is criminal miscellaneous number 458 of 2024, 458 of 2024, and it's difficult for the wife to travel. This court has held that the notice to the respondent sufficient. Next, having heard the counsel for the petitioner, for the material on record, considering the fact that the distance between both the places is about 120 kilometers, and considering the inconvenience being caused to the wife, this court deems it appropriate to allow the petition accordingly. So and so is withdrawn and transferred to so and so. Next.
Cell number 2, VP Sidramaya.
Yes.
VP Sidramaya for petition.
No representation for dismissal tomorrow.
Cell number 3.
No representation for dismissal tomorrow.
Cell number 4.
For respondent in this case, madam. Yes, my lord. She was arguing. After was referred to local mediation, my lord. It says that for the whole settlement, my lord. So it has related to the loss of time.
These matters are specially listed.
So it was argued before my colleague.
Then let your colleague come on Monday.
Yes.
We'll hear the matter on Monday.
And Monday I cannot attend, my lord. Monday I have inconvenience.
Tuesday
it can.
This is matter on Tuesday. No further adjournments on either of the requests. Yes.
Cell number 5 adjourned. Cell number 6.
Yes.
Shweta Ravi Shankar.
Ma'am, there have been applications filed by the
With the petitioners,
We have submitted the documents. Let the applications be allowed and the matter may be listed for final hearing.
What is this writ petition? Questioning what this writ petition is filed.
They have filed it for enhancement of maintenance, interim maintenance. And 35,000 was ordered by the lower court, your lordship. There are 75,000 there. 35,000 has been ordered by the lower court, which he's been paying. They have filed an enhancement of maintenance asking for 1,75,000.
What is your income?
The income is 2,05,000, your lordship, on the asset and liability, yes.
We have 2,05,000.
Yes, your lordship. So 35,000 has been ordered, which by the honorable.
Your lordship, this is 11,88,000. He is earning in US dollars, and I have produced all those documents. And let these applications be allowed, and kindly post this matter for final hearing on, because both of us discussed. So
this is not some final hearing matter, just an interlocutory application.
Because interlocutory application is with regard to IA-1 of 2024 is filed for production of additional documents. It is not for enhancing of maintenance.
Documents we can dispose of. We don't require so many hearings for that.
I have submitted all the documents, ITRs of 2023, everything has been submitted, your lordship.
Where are the documents submitted by you?
Your lordship, this matter may be taken up on 2nd of May, please. Because there were 3 applications which are listed for hearing.
Will not be adjourned on 2nd. It has to be finalized.
Yes, please.
This is matter on 2nd.
Yes.
Same like earlier matter. No adjournments. Sure. At the request of either of the parties. Next.
Cell number 7. Cell number 7.
This is a matter, my lord, between the husband and wife, my lord, with regard to the reconciliation.
With regard to reconciliation, now the daughter is ready for wedding, my lord. They are making the negotiation for reconciliation just to see that daughter is
This
getting.
is the MC of 2019.
Yes, my lord.
Why are we penning it
my
here?
lord, I don't dispute
no,
that.
what I'm saying is,
Yes, my lord.
we will decide what is before this court. If you want any negotiation, mediation, let it be done before the trial court.
Because the reason is, my lord, for this, my lord, my restitution for restitution of conjugal rights filed by the husband is accepted. My lord, that has been communicated to the respondent by of
What I'm
execution.
saying, the court is not coming in between the mediation. We will dispose of this matter. Let the mediation go on. If so you want, before the trial court. Let no matter be just like that stayed and pending before the court.
And I will ask my height on second, my lord, on that day you will ask me.
Yes. No, same in this also, second, no further adjournments. Next date.
Serial number 8.
Yes.
Anish Gowda.
First petition is concerned, my lord, the husband filed petition for divorce under 13(1), 1A and 1B. Whereas, my lord, IA number 7 filed under order 18, rule 17 to recall PW1 for further examination of petitioner. That application came to be dismissed on the ground that, my lord, the husband has not sought for divorce under 13(1), 1I, but he sought for divorce under 13(1), 1A and 1B.
Heard the learned counsel for the petition in part, no representation for the respondent. List this matter tomorrow as parted in the specially listed cases.
Interim order kindly be extended.
Tomorrow, till tomorrow, interim order is extended. Yes, next.
Serial number 9. Omkar Basavaprabhu.
For the petitioner in this matter, my lord. The petitioner is the judgment debtor. Lord, the respondent had initiated MC proceedings. Lord, the divorce was granted and an alimony of 6 lakhs was awarded initially. Subsequently, the same came to be enhanced to rupees 8 lakhs, my lord. The respondent has put the same for execution before the trial court. Lord, upon filing of the execution, my lord, the trial court, despite the fact that after the granting of divorce, the petitioner has paid an amount of 1,53,000 in view of the attachment in criminal.
Please come to the impugned order where it is.
My lord, page number 20, my lord. See, trial court orders that.
Let us read the impugned order, then you can make your submission. Yes.
Lord, the impugned order. The question whether the permanent the payment made in criminal miscellaneous is.
Come to page number 19.
Yes,
paragraph number 10, and please read.
Yes, my lord. The Honorable High Court, as per the judgment passed in MFA 4461 of 2019, has clearly held that the respondent shall deposit the amount of rupees 8 lakhs within the period of 4 months from the date of the judgment, that is 23/11/2022. Now, 4 months has lapsed from the date. There is no appeal preferred against the said judgment. It has reached finality. There is nothing mentioned about the payments made in criminal miscellaneous. Therefore, the respondent cannot avoid the execution of the decree on any grounds. He has to deposit the amount of 8 lakh rupees towards permanent alimony. Hence, point 1 is answered in negative. Point 2, the question whether the payment made in criminal miscellaneous is a part of permanent alimony or not needs to be inquired by giving opportunity to both the sides to put forth all relevant documentation and statements. However, the respondent needs to first deposit the entire amount of rupees 8 lakhs before this court. If the respondent is able to show after inquiry.
First tell the court, MFA order is dated 23/11/2022.
Yes, my lord.
When is the order in the criminal miscellaneous?
Lord, the criminal miscellaneous order. Lord, the details of payment is available at page number 44.
Details of the payment. Basing on what you have paid that amount, was it an order in the criminal miscellaneous, or it is an why you paid that amount? There should be something.
Yes,
rightly had.
My lord, with respect to that, my lord, interim maintenance was ordered during the pendency of MC proceedings. But this criminal miscellaneous is pending consideration even after disposal of the MC proceedings.
It's like this.
Kindly, my lord.
In a MFA, a permanent alimony is granted.
Yeah.
It is altogether a different order.
Yes.
And if something is pending for the interim maintenance,
Yeah.
that is a different order.
Yeah.
So, if any payment that is made in criminal miscellaneous, you cannot say that it is in pursuant to an order in MFA.
My lord, with respect to that, my lord, kindly page number 40 may be perused. Annexure D, page number 40. In criminal miscellaneous, a clear-cut order is passed by the court which is not challenged and which has reached finality. The order of attachment of, if I'm permitted to read out. The office is to issue intimation to the garnishee for the suspension of the order of attachment of salary of respondent number 1. the petitioner shall be accountable for the amount whichever she has received in this petition after the order of divorce by the Honorable Family Court hastened towards permanent alimony. This Honorable Court, my lord, while hearing the petitioner on the has granted an interim stay, lord, directing the petitioner to deposit the amount of the petitioner to deposit the amount of 5,67,000 that has been duly complied with. Lord, now what is left in the
Where from this order you are saying that pursuant to the orders in MFA, you have oh no, how the criminal court is concerned with the orders in MFA?
my lord, it is simply because
Whatever amounts that you have paid, that is pursuant to the order in the criminal miscellaneous,
Yes, my
not in
lord.
other matters.
Yeah, yes, my lord. With respect to that, lord, after the marriage gets dissolved upon the granting of decree, my lord, she has continued receiving the said amount in view of the attachment order.
That the court said, first you deposit the amount, we will decide.
Yeah.
And if you are entitled, you will withdraw that amount.
No.
What is wrong with the order?
Yeah, my lord, my predicament now is that, my lord, my salary is attached. Even after granting of the divorce, my lord, the sum of rupees 1,53,000 is taken out from my account. Lord, in addition to this, after filing of the execution, I have deposited an additional 80,000. And in view of the interim order passed by this Honorable Court, I have also deposited the amount of 5,63,000. So in total, my lord, as on today, I have paid the entire amount of 8 lakhs, my lord. Now,
No, it is lying before this court.
my lord,
5 lakh is lying before this court.
it is withdrawn by the respondent.
5 lakhs.
Yes, 5
When-
lakhs, the order, the deposit that I have
Order
made.
passed by the High Court.
Yes, my lord.
When was the order?
My lord, the interim order passed by this Honorable Court, my lord, is dated 23/4/2024, my lord. An interim order was passed directing me to deposit.
Pass this order.
Yes, my lord. 5,67,000. I have duly
So,
complied
no,
with
no,
the
no.
same.
Now this 5,67,000
Yes.
she has already taken. Now we will ask the court to adjudicate it.
Yes, my lord.
Yes.
She has already taken the amount. Lord,
Please
my
come.
predicament here, if I am permitted to make this submission, the money is taken out from my account. It is deposited by virtue of an attachment.
Don't expect the court to do all the exercise what a trial court has to do by the High Court. Now, the court has asked you to deposit 8 lakhs.
Yes, my lord.
Deposited 5,67,000.
Yes, my lord.
On that, this court has granted stay.
Yes, my
That
lord.
interim order, we made it absolute.
Yes.
And will direct the court to adjudicate the matter. If you have to pay, you will pay.
Yeah.
After adjudication.
Yes, my lord. Upon adjudication, my lord, the trial court may
Agreed
be
with the
directed.
orders passed by the executing court on in EX 3 of 23 dated 5/8/2023. The JDR is before this court. The decree holder has initiated the execution proceedings stating that as per the order passed in MFA number 4461 of 2019 dated 23/11/2022, the husband has to pay an amount of rupees 8 lakhs, and as he failed to pay the said amount, execution proceedings were initiated. But it is the objection of the judgment debtor, who is the petitioner herein, that an interim order has been passed directing to pay rupees 4 lakh per month, 4,000 per month to his interim maintenance and criminal miscellaneous number 897 of 2017, and that a sum of rupees 3,000 is being deducted from his salary. In spite of the order of permanent alimony, the salary deduction is being continued. The decree holder cannot claim both the amount, that is the permanent alimony, as well as the maintenance. It is his case that he has paid an amount of rupees 1,59,000 towards maintenance, and hence he is liable to pay only 6,41,000.
Lord, another 80,000 is deposited
From the
upon
order-
filing of execution.
That is from the order I am recording. The court had passed the impugned order, observing that the question whether the payment is made in criminal miscellaneous is a part of permanent alimony or not needs to be inquired by giving opportunity to both sides to put forth all relevant documents, statements. However, the respondent needs to first deposit the entire amount of 8 lakhs before this court. When this matter came up before this court on 23/4/2024, an interim order was passed whereby the petitioner is directed to deposit was directed to deposit an amount of rupees 5,67,000 within a period of 4 weeks from the date of receipt of the copy of the order. On such deposit, the wife is at liberty to withdraw the amount, and if he fails to deposit that amount within 4 weeks, the stay granted by this court shall stand vacated without further reference to the court. Next parallel, and counsel appearing for the petition submits that, as per the order passed by this court, he has deposited the amount, and even the respondent has withdrawn the amount. It is further submitted that he had made several payments, and without even considering them, the court had passed the impugned order. Though notice is served on the respondents, no wakalat is filed on their behalf. This court has heard the counsel and perused the order passed by this court and the impugned order. The whole dispute is that according to the petitioner, he had paid certain payments in the criminal miscellaneous, and that needs to be deducted from the amount from the amount of rupees 8 lakhs. Considering the fact that already an amount of rupees 5,67,000 is deposited by the petitioner, that the trial court shall adjudicate on the issue with regard to whether any payments are already made by the petitioner, the judgment debtor, and if further, whether any further amounts needs to be paid by him. In that view of the matter, the order impugned is set aside, and the matter is and the trial court is directed to consider the same and pass appropriate orders within a period of 2 months from the date of receipt of the copy of the order. Yes, next.
I'm grateful.
Yes. Allow. What you do is, now these two numbers or whatever disposal is there. Today 2 disposals are there, right, in this special listed cases. Those 2 register statistics to tell you these are the disposal matters, and remaining matters are there about 30 or 40. That will ask them to list it tomorrow. Whatever pertains to this bench, let them be listed. Serial number?
30, list number 2, serial number 30.
Yes. Yes.
The wife has filed original suit number 90 of 24, which is pending before Mysore Court. The husband is appearing in that cases, and subsequently in 2025 has filed.
Has filed. What is the suit?
OS number 6 of 25.
For what?
It is for restriction of conjugal rights.
Filed by?
It is filed by husband is pending in Tumkuru. The wife is residing in Mysore.
She filed?
She filed original suit number 90 of 24 and for dissolution of marriage.
Dissolution of marriage.
Yes, yes. And also JNWC.
The present petition is filed seeking transfer of OS number 6 of 2025, filed by the husband at family court at Tumkur to the family court at Mysore, where the suit filed by the wife seeking dissolution of marriage, that is OS number 90 of 2024, is pending. It is submitted that the distance between both the places
400 kilometers.
400 kilometers, and it is difficult for the wife to travel. Considering the same, there shall be stay of all further proceedings. Hand summons to the counsel appearing for the respondent before the trial court, and shall file a memo to that effect by 21st, if it is filed 21st July. If it is filed, list this matter on 22nd. In addition to this, the registry is directed to issue notice. Yes, next.
That.
What is the password?
List 1, serial number 1. Ask Shashidhara.
We'll see. Where is Mr. Shashidhara? Call it, just inform the court officer, it will be called. Yes, next. Next, call this list.
List number 4. Slave number 1. List number 4, slave number 1.
Yes, what about this? 1.
K.R. Anantmurthy.
Give
B.D.
that file.
Nanjundaradhya.
We'll see what is it. One is 2638 is dismissed. Two 639. Compensation is 7,000. Renuka, you're not concerned with this? You're not concerned?
Well,
This matter, you're not.
well, I'll appear, my lord, despite whether I'm there or not in KSRTC, my lord, they don't mind, my lord, if I appear.
This is the KSRTC matter.
Counselor, my lord.
K.R. Ananthamurthy.
The panel educator.
G.Chandrasekharaya.
Well, I'll do it.
No, it is entitled for compensation of 7,395.
Yes.
That is what is granted.
Probably on liability.
For it to Lokadalat tomorrow?
Yes, ma'am. Yes.
Tomorrow
Yes.
Lokadalat.
In fact, the law officer.
And other matter is, I think, that is a dismissed matter that we will not. 3439. Take
In fact, the
3439.
law officer told me that most of the cases are infractuous, my lord, where we have filed. Those days, my lord, Pranay Sethi case had not yet been.
That is against? MBC 2638. MBC, this MFA 3439, post after vacation, MFA 3440 of 2014, list is matter before the Lok Adalat tomorrow. Next two.
Yes, actually for the appellant in this case, my lord, it is a case for injuries. It is case for enhancement of compensation. Accident is of the year 2013, my lord.
Yes.
And she was working as a assistant registrar, City Civil Court, Bangalore by that time.
TCR is there.
No. Away from TCR.
G. Chandrasekharaya in this also.
Yes.
We'll make the calculation.
Yes, ma'am. Yes, ma'am.
And assistant registrar, City Civil Court, Bangalore, and she was drawing the salary of rupees, gross salary 53,035 and net salary was 36,095, my lord. And
Court
nature of court has not taken anything. Only para 8, my lord, only your general damages has been awarded. And your lordship may kindly see nature of injury is, that is fracture of lateral malleolus.
Please come to the reasons. It's a very small, short order.
Para 8 of the judgment, your lordship. Para 8, middle of the judgment, my lord. As per Exhibit P4 wound certificate, one fracture is observed. Accordingly, this court is obliged to award an amount of rupees 30,000 towards pain and suffering and to future medical expenses. Further, the petitioner has been awarded an amount of 10,000 towards medical bills, conveyance, nourishment and other incidental expenses and 20,000 towards amenities. She was hospitalized for 2 days, but she was under Exhibit P. 7 is the earned leave extract, my lord, according to which she was taken rest for 3 months. In spite of it, nothing has been awarded towards loss of income towards laid up period. Leaves surrender.
You have not examined the doctor.
No, doctor was not examined, but your lordship may kindly say leave surrender encashment benefit has to be given to her. 3 months she was not in a position to attend the office as Assistant Registrar of City Civil Court, Bangalore. For that, exhibit P7 has been produced. That is earned leave extract. That is exhibit P7 reads, Your Lordship may kindly, I will read. This is to certify that Srimati T. Narendra, the then Assistant Registrar City Civil Court, Bangalore City, has not drawn medical reimbursement among 26/8/2013 to 26/11/2013. So 3 months nothing has been given, my lord. And salary certificate is exhibit P6. And her gross salary was 53,000.
Matter also to the Lok Adalat tomorrow. Yes.
Can I? My lord, serial number 52 is settled, my lord.
52.
Yes, ma'am. Council is here, my lord. 3,50,000 lump sum, my lord.
One.
Serial number?
52.
52?
That is MFA 2101, my lord. 3,50,000 lump sum, my lord.
50,000 in addition.
Lump sum.
3,50,000 lump sum in addition to what has been awarded by the tribunal.
Then serial number
tomorrow Lok Adalat for filing joint memo.
Let's serial number 68, my lord.
50?
68, my lord. 68, my lord. 1742, my lord, MFA. 45,000 lump sum, my lord.
45,000 lump sum in addition to what has been awarded by the tribunal tomorrow before the Lok Adalat. Yes.
68.
Yes. Next.
Serial number. In previous matter, delay has to be controlled in
In which matter? Claimants appeal. 832 days delay condoned on condition that they are not entitled for interest. For the set period. And even in the order also, they are not that Lok Adalat reference order also. For so and so period, they are not entitled for it. Yes.
Serial number 3, Shashidhara or Shashidhara for appellant, New India Assurance Company.
Post after vacation. Yes, next.
Serial number 4.
What about this?
Well, in serial number 4, the claimant is no more, my lord. And they're already represented by the legal representatives. So therefore, my lord, that is first, my lord, the claimant number 1 dies, my lord, Narayan Pujari.
No,
Then
all
even
the
the wife
legal-
also died, my lord.
All the LRs are on record.
All on record, my lord.
So what do you say on the merits of it? On the merits of it.
They are challenging the liability. Initially, it was a case of injury malus. Subsequently, during the pendence of the claim petition, he died because of the injuries, claimant. So the wife and records, because they are contending that he died because of some other reason. But the tribunal has given finding that he died because of the injury sustained, as it was head injury.
My lord, 1 second.
Give the pen. It is submitted that a memo is filed stating that the R1 died. No, who died?
That's Ratna Netravati.
That is respondent.
R1.
R1 died and the
R2 to 5 are the LRs.
already the LRs are on record.
Please,
Accordingly, memo is taken on record and the necessary amendment should be carried to the cost item. Yes. So in this, the amount that is granted is 2,85,000.
5129.
Your file is missing.
My lord, it may be passed over, my lord. It's there. The file is there.
Take his file.
My lord, actually, if it is on, my lord, liability, I need my file, my lord.
Yes. Pass over. Next.
Serial number 5. Serial number 5, Ravi HK.
Who are the respondents in this?
That is Suguna.
Then for the needful shall be done within a week, or else the appeal shall stand dismissed.
Serial number 6.
Your Lordship, I am for the appellant. The LRs have not been brought on the record. The respondent number 2 is no more. His LRs has to be brought on the record. And the counsel for the liabilities on the R1. insurance companies placed ex parte in this order, Your Lordship. And
Next, next.
Till number
yes, Your
7.
Lordship.
It is a quantum, it's quantum, my lordship.
Much.
No steps to be taken in respect of deceased R3.
The quantum, we have already satisfied the award amount, my lordship.
Who is R3?
R3 is the owner of the vehicle, my lordship.
Oh, liability is on,
Company.
liability is on the company.
Yes, yes,
Then if it
company,
is quantum, we'll decide. Take
Three
that.
may be dispensed.
Huh?
Three may be dispensed.
What is that?
Respond
It is
number.
you have filed a memo.
Please.
Then
My lordship, it is 2010,
give a memo, we'll dispense with.
2010 accident, my lordship. 5,200 was taken.
Please come to the table. Oh, it is a case of death.
Death, my lordship.
Age?
36, my lordship. The tribunal by mistake and oversight taken 14 multiplier instead of 15 multiplier, my lordship.
That is
In
one.
para 17 of the judgment, my lordship.
And what is his income?
Income was taken 5,200 instead of 5,500. 40% is the future prospects, my lordship.
Given?
My lordship.
Future prospect not given. No, we'll calculate.
5,500, 2,200 is the future prospects, my lordship.
2,000?
200, my lordship. 7,700, my lordship. 1/4 deduction, my lordship. 1,925 minus
1,000?
1,925, my lordship.
Would be 1/4.
Yes, my lordship.
So then the contribution is?
5,775 into 12 into 14. No, 15, my lordship, because multiplier taken by the 15, my lordship. 10 lakhs 39,500, my lordship. 2 lakhs 40,000 is the convention rates, my lordship.
2 lakh 46.
40.
40.
30,000 is the funeral expense.
It's coming to
13 lakhs 9,500, my lordship.
13 lakhs.
9,500 as against 6 lakhs 85,200 was awarded by the tribunal, my lordship. So 6 lakhs 24,300 is the enhanced compensation.
It is submitted with the land counsel for the insurance company, the joint memo.
Yes, my lordship. And also that because the multiplier has to be discussed because judicial order is required, my lordship. Yes, my lordship.
No, because that is what is they will be ready to file a joint memo.
Because tribunal taken 14 multiplier, my lordship. By mistake, that's why, my lordship.
No, that
That ground is not taken in the argued in the appeal, my lordship.
Agreed with orders passed in MVC number 87 of 2011 dated 26 November 2012. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of ₹15 lakhs for the death of the deceased in the accident. It is a case of the claimant that is earning an amount of rupees
20,000 as stated by the
50,000 and the court had taken 5,000 as a salary.
5,200.
5,200 and as his age is 36 and the multiplier applied is 14.
Instead of 15.
14 and granted the compensation of an amount of ₹6,85,200. Land counsel for the appellant submits that the tribunal had not taken the income properly and further the multiplier is 15 and even in the conventional heads also the amount that is granted by the tribunal is on the lower side. The land counsel appearing for the insurance company submits that the tribunal had rightly granted the compensation. Next one. Having heard the counsels on either side, peruse material non-record. The accident had taken place in the year 2000?
10 minutes.
2010, hence this court is taking the income at 5,500. Future prospects at 40% will come to 2,200. That is 7,700. And there are 5 claimants.
Yes, ma'am. 1/4 deduction.
5 claimants, 1/4 has to be deducted towards personal expenses. That is 1,925. And his contribution to the family is 5,775 into 12 into 14. And it comes to loss of dependency 10,39,500. And consortium for 5 people 2,40,000. Funeral expenses 30,000. Legal expenses 10,000. Altogether, the claimant is entitled for an amount of 13,19,500. Accordingly, the appeal is partly allowed, enhancing the compensation from 6,35,200 to 13,19,500. The enhanced amount shall carry 6% interest. Then the memo is taken on record and notice to the owner of the vehicle is dispensed with as the liability is fixed on the insurance company. That is a docket order.
Delay of 1,700.
It's a docket order, that dispensation of.
Lot of delay is there, my
Delay
lord.
is how much?
1,744
IA
days.
number so and so is filed to condone the delay of so and so. And for the said, the delay is condoned on the condition that the claimant is not entitled for interest for the said delayed period. Yes, next.
Serial number 42, my lord. Serial number 42.
42.
7 lakhs lump sum.
One. Serial number 42.
Yes.
It is submitted by the council. It is submitted that the RTC. Renuka, RTC is ready to.
Yes.
The RTC is ready to pay an amount of rupees.
7 lakhs.
7 lakhs.
7 lakhs.
7 lakhs. In addition.
Yes, in
In addition to what has been awarded by the tribunal. It's a no interest. Lump sum amount of.
Along with interest.
But it's inclusive of interest.
Lump sum amount of 7 lakhs.
7.
Yes, next.
I have an.
And for this matter, Lok Adalat for filing a joint memo tomorrow. Yes,
That I1 may be dismissed as not.
not necessary. It's a Lok Adalat. You don't have to look at that. Next.
Delay. Serial number 8. Renuka HR.
Yes, what about this?
8 is. My lord, in
Notice
8
is not served in this.
My lord, in 8, it's, the only issue is, my lord, I have challenged on the ground that in under 163, he is not arrayed the rider, sorry, insurer and insurance company as a party, my lord. It's a 163A claim, my lord, he has come against me, my lord. He was the pillion rider. So therefore, to that extent, it goes, my lord. The only interference your lordship could make it is.
No, but notice is not served. Now we
Oh, I'm
can't
so
enter.
sorry, my lord, I didn't see that.
Notice to the respondent.
Awaiting.
Post after service of notice. Next 9.
Serial number 9. Sri Harsha AK.
For appellant, my lord. My lord, respondents are insurance, KSRTC, my lord. Respondent number 1 is a driver. My lord, earlier I paid process, my lord, to
No,
respondent.
what is, no, anyhow they are there.
RTC.
RTC.
KSRTC.
So what is the issue?
My lord, my lord, here injuries are grievous in nature, my lord.
Look at it. Please
My lord, it
open.
may be referred to Lok Adalat, my lord.
No, we'll make the calculation and refer it.
In fact, I'm taking the help of Pradeep, my lord. We are
That's
doing
what,
it.
Pass
open
over.
that, the.
Pass over, my lord.
My lord, if it's
pass
only
over.
Quantum, my lord, your lordship need not have to trouble. Will not trouble your lordship, my lord. If it's only quantum, we'll do it and report,
Yes.
my lord.
Pass.
Yes. Next.
Serial number 10. P. Palakshaya.
What about this? Take that file, give that file. One lakh is granted in this. Renuka, this is for enhancement.
Yes.
Tomorrow for.
The other side is there, my lord. Claim
No,
it
we'll
says-
say we'll post it for Lok Adalat.
Yes.
HR Renuka is directed to take notice on behalf of the respondent insurance company. This is matter before the Lok Adalat tomorrow.
Serial number 11.
Yes. This also, I think the same one. Let's see. HR Renuka is directed to take notice on behalf of the respondent corporation. List this matter before the Lok Adalat tomorrow. Yes, 12.
Serial number 12.
Give that file. Same. HR Renuka and tomorrow. Yes, 13.
Serial number 13. P. Palakshaya.
Give that. Is this smarter before the Tokudara? Renuka, this next
Cell number
14, notice to the respondents.
Cell number
No,
15.
the not notice to the respondents. The process shall be paid within a week, or else the appeal shall
I'll pay
stand.
for a week time.
Yes, yes.
I'll pay for a
Yes,
week time.
Serial number 15, FP of appellant, my lord, only a week time may be granted, my lord. We'll do the needful. 15 and 16, my lord, both.
Time is granted to do the
Cell number
needful.
16.
16 also same, my lord.
Same.
Cell number 17.
I am okay for the appellant,
17.
my lord.
Vijay Kumar T.
Seeking enhancement of compensation.
Hmm.
Kindly pass.
Yes, pass over. 17 pass over. Next, 18.
Cell number 18.
My lord, 18 is liability, charge sheet against the car driver, my lord. Whereas-
For taking steps, a week's time, default order is 19.
Cell number 19. Karthikeyan.
Acknowledge for having deposited 50% of the award amount. It is by the RTC. No, same for steps, a week's time, 20.
Cell number 20.
For the appellant, my lordship, needful is done. We have served IAS 2 sets.
For enhancement.
Yes. Yes, my lordship. 2
Not the
sets of
needful.
IAS filed.
No, you can talk to Mr. Pradeep.
Sure.
Yes. This also passed over 20.
20 pass over.
21.
Cell number 21.
Copy already served 2 times, madam. Copy already served 2 times, madam.
T. Vijay Kumar.
Enhancement of compensation. You can, yes, pass over. 22.
Cell number 22. Radha BP. Charandeep Faragan.
Yes. Who appears to the respondents? 22.
Charandeep. For R1.
For taking steps, a week's time. 23.
23.
23 notice maybe.
Step research.
Memo, take that memo. Memo is facing dispensation of notice to
R2.
R2 dispense with the risk of appellant. Then what about?
Connected appeal has not been posted.
So this is for enhancement.
For 52/11 of 21.
No, this is for enhancement.
My appeal is for enhancement.
Their appeal is there.
Two insurance companies are there. That's
Oh, Lord, this is matter after vacation along with.
52/11 of 21.
Please write it on a paper and give them.
5211 of.
Yes, along with that appeal. Next, 24.
Cell number 24. Shankar Gaudji.
Take that. There's Shankar Gaud.
24.
24.
Yes, ma'am.
On quantum or on liability?
On quantum, it's a damage in respect of a bus. 2 buses have collided. It requires evidence.
After vacation. Yes, next. 25.
Number 25.
It is liability issue, my lord. 2 vehicle is involved.
For
Steps, my lord.
process, for taking steps, a week's time is granted.
Please.
Cell number
Default order. Next, 26.
26.
This also for steps, a week's time.
Cell number 27.
This also a week's time.
Cell number 28.
A week's.
ASRTC Malad, HR and committee.
No, 28.
28, please, 29 for the appellant in this case.
Respondent, you want,
Yes.
yes. Pass over?
Please
pass over.
Cell
Yes,
number
next
29.
29.
29. Dayanand Subrai Gowda.
For steps, a week's time.
Cell number 30.
30 to 34, 1 week.
Srinivasan.
30 to 34.
Enhancement.
Enhancement, my lord. Some other cases are there, my lord.
No, this we can decide if you can,
Yeah.
RTC is the one.
In the connected cases, my lord,
Uh.
so K. Nagaraj is in another 6 matter is there. I have given copies to law officer.
No,
Please.
they're here. If it is possible, we can settle it.
K. Nagaraj is not there.
K. Nagaraj.
In connected cases,
No, as far as this matters are concerned, she can, Renuka can do it. Just if it is feasible, then we'll see.
I have not
Huh?
file, not.
Take the court's file. We'll see if it is possible. Give all these files to him. Till 37. Renuka, see that there are about 7 matters, sir. If there is any possibility for settlement.
Yes.
Cell number 35.
No, till 37.
And 35 is also there.
My matter is, my lord, my matter is 30 to 34 and 36.
So matter is 30.
30 to 34 and 36, my lord. 35 is not mine.
Oh, 35 you are not yours. Yes. Call 35.
In this case, appear for appellant, my lord. One, the income matter, my lord, enhancement. Please, I calculated the amount also.
You can talk to them, pass over.
Please.
Yes, 35 pass over.
Number 37.
37 is grievously injured, 20% disability is there. Here the matter.
Also, you can negotiate on that.
Future perspective, they will not consider.
37 for taking steps a week's time.
Call for record, Miller. Call for TCR also.
No, let it go. For
Please.
Yes, next.
37.
The time for the respondents. Another connected matter is there, Your Lordship. MFA 6351 of 2019.
So post along with that after vacation. Next 39.
Number 39.
My lord, I am for appellant. Actually, accident is of the year 2018. My lord, I filed an IA for permitted to withdraw. My lord, IA may be
liability, my lord. You are on liability. Yes, this is matter for final hearing. Yes, next.
Number 40.
My lord, I filed an IA. My lord, it is required.
No, in this. No, I have seen on liability we will not grant. IA number 39.1. IA number 1020 is filed to condone the delay of 65 days condone. Next, third 40.
Number 40. Renuka HR.
What about this?
What is liability? Liability.
IA number 1 of 20 is filed to condone the delay of 192 days. Condone, admit, post for final hearing, call for the TCR. Yes, 41.
Number 41. 41.
IA number 1 of 20 is filed to condone the delay of 127 days in filing, condoned, admit, post for final hearing, call for the TCR.
42. For local 43.
Negligence. IA number 1 of 22 is filed to condone the delay of 7 days in filing, condone, admit, post for final hearing.
Number 44.
What about 44?
Number 44. Renuka HR.
It can be disposed of. Yes. No, take that. Stay up. Yes.
Well, a case of injury, and the claimant is an, he says, my lord, he's an advocate and an agriculturist. And
no, how many are the injuries?
Well, only one.
One injury.
One claimant. My lord, injury, my lord, is compression of fracture of vertebra.
One fracture.
One fracture. Fracture of compression. Compression fracture of vertebra.
40,000.
And he was an inpatient, my lord, for 4 days.
How much is granted by the court?
My lord, the pain and suffering is 20, my lord. I'm not on that. I'm only on loss of future earnings. Come before the court.
No, what is the disability according to the doctor?
Well, the doctor says 34% of the limb and 20%, 21% of the whole body. It can't be 21%.
So it should be 13%.
Yes.
13?
Yes. Well, 13 also would not come, my lord. 34 means, my lord.
34.
39 would be probably, my lord. Your lordship could take it as 12% or 11%. Since he's an advocate, your lordship could take it 12%.
It's coming to 11.3. It could be 12.
12%.
So loss of amenities, it can be 30,000.
Yes. Yes.
Then he was there in hospital for 4 days.
4 days.
Food, nourishment and attendance charges 5,000. Then loss of income during which year is the accident?
2018, man.
9,000. How much? 15,000.
Yeah.
Income should be.
MACT has assessed 15,000.
Has taken 15,000.
Yes.
It should be 15,500. 2,000 you said?
Well, MACT has taken 15,000. Para 18, man.
No. Which year is the accident?
2018, man.
18 it should be. There is evidence?
No.
Let's see that.
No. I have said that my grounds of appeal, my lord, is that he has not produced tax returns or any documents.
So
my
let
lord,
us see how the court has come to that conclusion.
Para 18, ma'am.
Regard to disability, so and so.
Sorry, para 15, my lord. Para 15, ma'am. 1-5. Since he's a practicing advocate, the court takes it as 15,000.
No. No, for an advocate,
in fact, he has not even produced the enrollment certificate.
No, no. So, like,
nobody will say that he's an advocate, my lord.
As per the table, it is 9,500.
Yes.
Court had taken 15,000. We will take 13,000. Laid up period. So 13,000 into 12. What is the multiplier?
16.
Which year is this?
16, my lord, multiplier.
16 into 12. It comes to 2,99,520. Then loss of income during laid up period. So 13,000 into 3. Comes to 39,000. Loss of amenities.
20,000 is
30,000. Expenses.
more or less.
Future medical expenses?
My lord, it's not there. It's not there. In fact, my lord, he says he underwent K-wire fixation, but there's no evidence, my lord. Even for the treatment, what he went through, my lord, there's no evidence. Therefore, future medical expenses.
It should be. It will be like.
I think it might exceed, my lord.
Then we will dismiss your appeal.
Yes.
19520. 39. It's coming to 3,73,520. 3,73,520. It is less than that.
Lordship could dismiss my
Who appeals for the respondent? Notice is served. Heard the learned counsel for the respondent. Appellant in part. No representation for the respondent. This is matter as part heard on Monday. Next.
Number 45.
My lord, since he has, I think my case could be dismissed because there's no cross appeal.
No, it is. It can be reduced.
Oh, I'm so sorry.
It is about 80,000 or 90,000.
And if he comes, my lord, the argument is much more, my lord, because he has not suffered the injury what he states.
No,
because there is so much of variance in the medical.
They have granted 4 lakh and odd. It is coming to 3 lakh and odd. Almost a lakh's difference. Yes, 44. It's over. 45.
Claim petition was dismissed.
Dismissed.
Settlement, because he wants to go.
Which one?
Serial number 21.
Serial number 31.
21.
21.
1,35,000.
1 lakh.
Then number 21. 21.
1 lakh?
35,000. Lump sum.
1 lakh 35. It is agreed to pay 1 lakh 35,000 lump sum amount in addition to what has been awarded by the tribunal. Same Lok Adalat tomorrow. Yes.
One more. 53, madam.
53.
2 lakhs.
1 minute. 53.
2 lakhs.
2 lakhs in addition. 2 lakhs lump sum in addition to what has been awarded.
Delay of 371 days.
A delay of 371 days condoned on condition. And even in 3,50,000, 52 also there is delay. 832 days. I think it is condoned on condition.
Serial number 66.
Huh?
66.
66.
40,000.
40,000. 40,000 lump sum in addition.
petition.
My lord, there is one more, my lord. 35, my lord, 4 lakhs.
1 minute.
60 ಅಲ್ವಾ? 66.
35.
4 lakhs.
4 lakhs in addition, lump sum in addition to what has been awarded. Yes.
35. 4 lakh.
Any other one? Next, call the list.
45 is,
Yours is 30?
45.
45.
Claim petition has been dismissed by the trial court, my lord.
IN number 1 of 23 is filed to condone the delay of 239 days in filing. Same is condoned on condition if, in case he succeeds in the appeal, he is not entitled for interest, admit post for filing. Upper KSRTC, HR Renuka is directed to take notice. Call for the records, call for the TCR. Yes, next.
Serial number 9, my lord. 9. My lord, 15,000 plus interest. Can there be
Less interest.
judicial order?
You want a judicial order?
Court order.
That is.
15,000 plus interest.
46.
9.
46, I am for the appellant.
One minute. 9 is Sri Harsha AK.
Sri Harsha AK. 50.
MFA 2467.
Okay.
Will not mention like this. We are putting her in trouble. We'll ask them to wait. I think we can wait.
We will take this matter, or else we'll do one thing. This matter, list this matter as part heard, serial number 9, MFA 2467 of 2020 tomorrow. We'll pass order tomorrow.
Please, ma'am.
Come back to the list.
Serial number 46.
There is a delay, my lord.
Is it for enhancement?
It is enhancement, but my lord, they are saying only 1 lakh. So that time not agreeing.
IN number 1 of 23 is filed to condone the delay of 355 days in filing. Condone on condition, admit post for final hearing TCR. Yes,
Please.
47.
Serial number 47. D. Vijay Kumar.
Same, IN number 1 of the 23 is filed to condone delay of 58 days for the reasons stated. Condone post for final hearing
Serial
TCR.
number 48.
Yes, 48. Mr. F.S. Zawali, Prasanna Shetty. This is matter for Lok Adalat, before the Lok Adalat tomorrow.
Delay of 20 days.
Yes, IN number 1 of 23 is filed to condone the delay of 20 days. Condone.
Serial
This
number
is matter before the Lok Adalat tomorrow.
49. Serial number 49.
Shantarash, IA 1 of 23 to condone the delay of 295 days on condition.
After the final.
Admit post for final hearing TCR.
Serial number 50.
This also IA 1 of 23 to condone the delay of 242 days in filing. Condone. This is corporation appeal. No, this thing. No condition. Yes, 51. Call for the TCR.
51.
Quantum,
Lakshmi Rao.
quantum notes. He's 70-year-old. An appeal by KSRTC. He's 70-year-old, lords. 14,000 was taken. Number 1. Number 2, my lords, loss of dependency. 2 married daughters are there. 1/4 was taken. That is wrong. And love and affection was taken in spite of awarding consortium. Love and affection was taken. These are 3 points.
Then I think this can be heard. I'll have it as a part of IN number 1 of 24 is filed to condone the delay of 260 days in filing. Condone for the reasons stated. This is no representation for the respondent. This is matter as part heard tomorrow. Next.
Serial number 52, 53 before Lok Adalat. Serial number 54.
Yes, 54.
54.
After vacation.
Suresh Shetty.
After vacation.
Serial number 55.
Ready, ma'am. Disability on quantum.
Srinivasan Nembai. Ready.
Serial number 55. Renuka HR.
Probably the first ground, your lordship, I think the first ground, my lord, what I have said is that the accident occurred on a Mysore-Bangalore highway, and the bus was getting into the bus stand, Chenpatna bus stand. At that time, the rider of the bike came there, and I have said that there is contributory negligence, my lord. probably your lordship could leave that.
No. It can't be in the local.
Well, at court order, my lord. That's
Then
all, you know, and there is only one ground, my lord.
No, then we will see. Like after vacation, next 26.
Serial number 56.
No, what about this?
This is an injury, grievance injury. We have asked for the enhancement. The lower court have attributed as contributory negligence, my lordship.
You can negotiate with them and then you can tell the court, pass over. Yes, 57.
Serial number 57. Uma MC.
Both these,
Yes, sir, it is my lord. Next week.
both these matters after vacation. Yes, 58.
Serial number 58.
What about this, 58?
HR Renuka.
Enhancement, my lord. Case of injury.
Yes.
But 30,000 is granted.
30,000?
30 is granted, my lord, in both the cases, and that 20 could be granted and so.
My lord, in local of the connected matter, 35,000 was awarded in 2021.
In each
They
case,
she's
it's
saying
different.
above another 20.
In Adalat, 35,000 granted.
Another 35 is granted in
Yes,
other
ma'am.
matters.
All the
Well,
connected
it's-
matters.
my lord,
In all the connected
Yeah, there are
matters.
6 connected matters.
Give her that order.
the injury is different, my lord. That's the reason these two cases were not settled, my lord. It's a simple injury, my lord, in both the cases.
In all the cases, simple injuries, man.
Show the order to her.
I will show.
Pass over.
Maybe passed over, my lord.
Pass over.
Serial number 59. Shripad V. Shastri.
Well, in a case of death, my lord, it can be disposed of, my lord, only. It can be disposed of. Brother and sister are the claimants. My lord, the accident is of the 2016, my lord. He has a technical engineer, a minimum as per chart income may be considered, and 50% may be considered as a loss to the estate. Compensation may be calculated, my lord.
So which year is
according
the
to me,
accident?
well, 2016, that means 9,500 plus 40% means 3,800.
2016 is.
It comes to 13,300, madam, after adding 40% of future prospects. Madam, 50% is required to be deducted. That comes to 6,650. Into 12 into 18, it comes to 14,36,400 in the place of 1 lakh. (2016) accident. Bachelor's death, claimants are brother and sister. 50% is required to be considered as a loss to the estate. Multiplier 18 is to be adopted.
18, this 16, my lord. He is the age of 31 years. 31 years, my lord. As per the para 15 of the judgment, his age 31 years.
What is the multiplier?
Milad, 29 years, 17 is the multiplier. Non 18, by mistake, I calculated as 18.
17 or 16 is the multiplier.
Multiply 20, 16, sorry, Milad, 16.
16, my lord. He is age of 31 years.
Milad, 26 to 30 years, it is 17, Milad.
It comes to 12,76,800. How many are the dependents?
Milad, only 2, brother and sister, Milad.
My lord, he is a bachelor, my lord, 50%.
Yes, bachelor 50% only.
It is already done. It is already done. 88,000, 36,000. Now you can file a joint memo.
Well, it is not possible because it is a large difference. That may be, so any judicial order may be possible. It's only my request.
It is coming to 14,10,800. This is heard the counsels in part heard.
Date, my lord.
How much?
Is it tomorrow, my lord? Sir.
Tomorrow for orders, Mr. Shastri.
Yeah, much obliged.
58, it is agreed that they'll pay an amount of rupees 35,000 in addition, lump sum, in addition to what has been awarded tomorrow before the Lok Adalat. Huh? Two cases. All these matters, remaining matters. Let the list continue to go.
My lord, serial number 67, my lord, my name may kindly be deleted, my lord. Serial number 67, my lord.
Yes.
My name may kindly be deleted, my lord.
Yes.
Much.
All these matters will come tomorrow. Renuka, all these matters will come tomorrow again in the list.
Yes.
Remaining matters.
Well, the matters which are
ಪಾಸವರ ಐತಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ರಿ ಮೇಡಮ್ ಸರ್ ಅಪ್ಲಿಕೇಶನ್ ಮೇಡಮ್ ಪಾಸವರ್ ಆಗಿತ್ತಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಮೇಡಮ್ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಪಾಸವರ್ ಆಗಿತ್ತಲ್ಲ ಅದು ಆಫ್ಟರ್ ಒಕೇಶನ್ ಅದು ಆಫ್ಟರ್ ಒಕೇಶನ್ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಮೇಡಮ್ ಇಲ್ಲ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ಸೀರಿಯಲ್ ಮೇಡಮ್ ಸರ್ ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಆಫ್ಟರ್ ಒಕೇಶನ್ ಹಾಕ್ರಿ
ಒಂದು ನಿಮಿಷ ಇರಿ ಸರ್, ಒಂದು ನಿಮಿಷ ಸಮಾಧಾನ.